All right, ladies and gentlemen, let's go on the record here. State of Florida versus Terrence Davis. Okay, State of Florida versus Terrence Davis. This is case F-20-14391. May I announce?
Good morning, Your Honor. May it please the court, Anna Marie on behalf of the state of Florida. Good morning, Jennifer Garcia on behalf of the state of Florida. Good morning, Your Honor. Assistant Public Defender Mendez on behalf of Mr. Terrence Davis.
Okay, very well, thank you. And Mr. Davis is present. I've already sworn Mr. Davis in, and the jury will be brought in a moment. We've addressed the last motions in limine, and we're ready to go.
You ready, Your Honor?
We are, thank you.
All rise for the jurors.
Thank you, ladies and gentlemen. Please be seated, everyone. Thank you. Good morning, ladies and gentlemen. How are you all doing today? Ladies and gentlemen, Robert, we have live mics, so I have to just make sure that we're good. I was getting a little background. Yeah, we're good. Ladies and gentlemen, you have been selected and sworn as the jury to try the case of State of Florida versus Terrence Davis. As you know, this is a criminal case. In this case, Mr. Davis is charged with one count of being a convicted felon in possession of a firearm. It is your solemn responsibility to determine if the state has proven that the defendant has committed the crime charged beyond and to the exclusion of every reasonable doubt. Your verdict must be based solely on the evidence or the lack of evidence and the law. As I told you yesterday, the information that was filed against the defendant is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to decide which laws apply to this case and to explain these laws to you. It is your responsibility to decide what the facts of the case are and to apply the law to those facts. Thus, the province of the judge and the jury are well defined and do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys an opportunity to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make a final argument. And following final arguments, I will instruct you on the law that is applicable to the case. After the instructions are given, anyone chosen as an alternate juror will be released. The remaining jurors will retire to consider the verdict. I admonish you not to form any fixed or definite opinion about the merits of this case until after you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you are not to discuss this case amongst yourselves or with anyone else. During the course of this trial, we'll take breaks. We'll take meal breaks. We'll take comfort breaks. You're allowed to separate and go about your personal business. However, during the recesses, I'm going to remind you again constantly, do not speak with anyone about this case or permit anyone to speak with you about the case or in your presence about the case. If anyone attempts to speak with you about the case, please advise them you're on the jury. If they persist, please report that to Robert, my bailiff, who will bring that matter to my attention. This prohibition applies to the lawyers on the case, witnesses, my staff, and third parties. If you see us outside of the courtroom, we're going to continue to ignore you. We're not going to answer questions. We're not going to even say hello. Please don't find that anyone is being rude to you. All of us are invested in maintaining the integrity of these proceedings. This case must be tried by you only on the evidence that is presented during the trial, in your presence, in the presence of Mr. Davis, the attorneys, and myself. You are not to conduct any independent investigation. You are not to go to any of the places that are described in the evidence or read or listen to any reports that may exist regarding the case. You are not to discuss this case, again, amongst yourselves, with the attorneys, with Mr. Davis, or anyone else, including witnesses, until after your deliberations are concluded and you are discharged. As I advised you yesterday, in every criminal proceeding, a defendant has an absolute right to remain silent. At no time is it the defendant's duty to prove his innocence. From the exercise of a defendant's right to remain silent, you may not draw any inference of guilt or hold it against him in any way. The fact that a defendant does not take the witness stand must not influence your verdict or enter into your discussions in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. They have a duty to make objections they believe are proper. When an objection is made, please don't speculate as to why it was made. Likewise, if I sustain an objection, which means I'm going to prevent the witness from answering the question or piece of evidence from coming in, please do not speculate on what might have been said or what might have occurred had the witness been permitted to answer. During the trial, occasionally it's necessary for me to communicate with the attorneys at what we call sidebar conferences, which is right here in the sidebar. These are matters, it could be scheduling or matters of law, but these are matters for me to address. Generally, we say it's outside of your presence. If it's only going to take a few moments, it'll be in your presence, but I'll put the white noise on and don't attempt to try to listen in on what we're talking about. But it's because it's not for your concern. Understand, if an attorney requests a sidebar conference, I may say reserve. Doesn't mean I'm mad at them. It just means that I want to wait for a more appropriate time to address whatever I anticipate the issue might be. And if these matters are going to take longer than a few moments, we'll send you out on a break. Okay? All right. Let me talk to you about taking notes. Now, each of you have been given an envelope. Inside of that envelope is a notepad. I do permit you to take notes during the proceedings. I need to caution you about note-taking. Notes are only to be used to help you recall what transpired during the proceedings. Your job as jurors is to listen carefully, pay attention throughout the entire proceedings, and ultimately, in reaching your verdict, you are to rely on your independent recollection of the evidence that's been presented to you. You can use notes if you like to help you have that recall. But again, they're not a substitute for having an independent recollection of the proceedings. And please, again, don't get so distracted that you are not paying close attention to what's occurring in the courtroom. Now, on your notebooks too, they'll be identified. You'll put them back in your folders. When we take breaks, if you leave, they'll be left at your seats. No one else has access to that information. Again, you can take them, don't have to take them. There's no requirement. That's up to you. All right, very well. Let's start with opening statements for the state. And please, again, you'll be using the podium right in the front there. Very good.
I want to thank you again for being here with us today.
And counsel, you're going to need to, because the mic is going to pick everything up, you can either, if you want to turn your podium a little bit, but you need to stay close to the,
This podium, not
correct, right there. Or you can use that, well, we're not going to be able to see you there, so turn that podium if you like.
I'll stay right here.
Okay, that's very good. Just keep your voice up, madam. Thank you.
You all heard yesterday, over and over again, that it is the state's responsibility, the state's burden, to prove this crime. That is right. And that is exactly what Ms. Danilo and I are going to do here today. Truth is, we don't get a lot of cases where we get to see the crime being committed. You get to see that today because we have video. You will see video from the officers that were calling us witnesses. You will see video that proves the two elements that Ms. Danilo spoke to you about yesterday during jury selection. That this defendant, who was a convicted felon, was in possession of a firearm. You will hear and see that Officer Roll and Officer Harrell were called to the scene to investigate an unrelated crime. During the course of their investigation, they noticed someone moving in the back seat of a car that was parked right in front of them and had its engine running. Officer Roll will tell you that for his safety and the safety of everybody else in that scene, he went to investigate who that was and what they were doing there. As he approached the vehicle and he looked in with his flashlight, he saw the defendant laying down in the back seat, face up, and he saw a firearm sticking out from right underneath his body, right by his thigh. He will tell you, he came in contact with the defendant. When he didn't get a response, he did what he was trained to do. He removed the firearm, took it out of the car, put it in the trunk of the vehicle, put Officer Harrell in charge of the fire. Officer Harrell will tell you, he became in charge of the firearm, he held it, he made it safe, and we'll go into about what that means, making it safe later on. He noticed it was loaded, he took a bullet out of the chamber, had a loaded magazine in there. Ladies and gentlemen, you will see that there was nobody else in that car. Nobody else in the back seat, nobody else in the front. He was the only one in there. You will also see that the gun was not in the glove compartment. It wasn't hidden in the center console. It was not tucked away from view under a seat. It was right under him. This cold piece of metal was right under him. You will get to see the gun. You will get to see the bullets. Now, ladies and gentlemen, at the end of this trial today, we will have to reach a conclusion based on the evidence. The video, the testimony, the gun, the bullets. And you will see that the only possible conclusion to be reached is that this defendant was a convicted felon, was in possession of that firearm. There's no exciting mystery here for you to solve. There's no mystery at all. There's no mystery as to what crime was committed, and there's no mystery as to who committed it.
Thank you, counsel. For the defense.
Mr. Davis just wanted to sleep. It's 4 in the morning. He's in the backseat of someone's car, asleep in a motel parking lot with no shirt on. When I say asleep, you'll see he is asleep. Stone cold, passed out, knocked out, asleep. He doesn't wake up.
Oh, go ahead.
He doesn't wake up when the police are up. He doesn't wake up when they start talking to people, multiple people, right in front of the car he's sleeping. He doesn't wake up when they open the door to the car. Doesn't wake up when they call the fire. Takes officers prodding him, talking to him, and you'll hear hitting him to wake him up. When Mr. Davis wakes up, he's running. He's disoriented. He's upset. He's upset because he's just woken up, because now he's being asked questions he cannot possibly answer. If he's being asked about a gun, he doesn't know that. So in this case, as the state said,
Keep your voice up, counsel. I'm sorry. Thank
the
you.
state has the burden to prove this case beyond and to the exclusion of all reasonable doubt. But what we'll see is that exactly like the state said, the officers didn't think there was any mystery. So the officers made assumptions and will be asked to fill in the blanks. Because the government could have absolutely definitively proved who knew about that gun, who handled that gun, who actually possessed that gun, and they didn't do it. So you'll see that the gun was never examined for fingerprints. It could have been, but no one tested it. It could have been sent to a lab, have DNA collected, but no one requested that. He could have known if other people or who or which other people were going in and out of that car, that there was surveillance video at the motel. And no one collected it. Officer Rule may tell you that he heard Mr. Davis say it was his gun, but his body-worn camera didn't capture that. And the body-worn camera you will see will show someone who was half asleep, groggy, disoriented, confused, and mumbling. The state has the burden of proof in this case. They have to prove that he knew about the gun. And they're going to say, well, he was next to the gun, so he could have known, so he should have known, so he must have known. What should have been the word is not enough. By the end of this case, you also will not know anything about that gun. It's not Mr. Davis. He never possessed it, and he never knew about it. Mr. Davis is not guilty.
State, you may call your first witness, please.
Yes, at this time, the state votes Omar Rule.
Omar.
So would you please step forward, face the clerk, raise your right hand to be sworn?
You solemnly swear affirm the testimony you about to give will be the truth, whole truth, nothing but the truth, sir.
I do.
You can be seated.
Please come on over here to the witness stand. I'm going to ask you to speak nice and clearly and loud into the microphone. Thank you, sir.
Your Honor, permission to have the witness remove his mask if he's comfortable.
He's comfortable with that.
Thank you. Can you please introduce yourself for the record?
My name is Officer Omar Rowe, North Miami Police Department.
And how long have you been employed with the North Miami Police Department?
With North Miami, 7 years.
And were you ever previously employed as a law enforcement officer anywhere else?
No,
Counsel, I'm sorry. If you move the mic towards you a little bit, let me see if that's better.
Hello?
Much better, thank you. Mhm.
What is your current position, officer?
a road patrol officer and a field training officer.
So what are your duties and responsibilities as a road training, or let's start with the patrol officer, as a patrol officer?
Respond to calls for service, community checks, and pretty much anything where it involves the city of North Miami on a police level, involved level.
Do you have direct contact with the citizens
Yes,
in North Miami?
yes.
Now, what are your duties as a, you said, field training officer? What are your duties as a field training officer?
Duties were based to train, advise, and monitor new hires to the department.
Actually, probably sit back a little bit and just speak loud. Let's try that. You have a good deep voice.
Did you get to finish, officer?
Yes,
Okay, thank you. Were you employed as a police officer and a field training officer on October 16th of 2020?
yes.
What shift were you working that night?
Midnight,
How many shifts are there?
3.
And midnight is, can you give us the times?
Midnight shift runs from 11 p.m. to 9 a.m.
So if you were interacting with civilians and handling your police duties, you would be doing it during that time.
That's correct.
City of North Miami is pretty large.
Yes.
What area were you specifically working on October 16th, 2020?
On a particular day, I have no specific assigned area. To train, I was assigned citywide.
That means that if a call goes out, do you just go to that call?
Yes.
And who were you training on that day?
Officer Moses.
Now, on that date, October 16th, 2020, did you receive a call to go out to a specific location?
Yes.
And what's that call when you receive a call to go out to a location?
Dispatch.
All right, hold on. I'm gonna try something. So it's comfortable for you. Just a little bit. I'm just trying to get the distance right so we can hear you well, but not have interference. Let's try it now. Go ahead.
So you don't even have to feel free to look at me, you can look at the jury, I know I'm hiding from you, okay? All right, so was that location a Motel 7 at 13445 Northwest 7th Avenue, Miami, Florida, 33168?
That's correct.
And that's in Miami-Dade County?
That's correct.
Now, are you with Officer Moses at this time?
Yes.
And how do you arrive at the scene?
Repeat the question.
How do you arrive at the scene?
Dispatch.
Okay,
Once we arrived on scene, there was numerous persons moving about. There was vehicles. A lot going on the scene at that time.
okay. Were you dispatched to an unrelated criminal incident at this time?
Yes.
Okay, so you didn't know what was really going on when you showed up on the scene?
No.
You were kind of just figuring it out as you were going along.
Correct.
Now, a picture for me. You said there were people all around. It was a Motel 7, but can you give us any more detail?
Yes, it was Motel 7, the motel in the city. Once I got there, there were other officers on scene prior to my arrival. The person going back and forth with argument, it was kind of a chaotic scene. We were trying to figure out, what's going on.
Okay.
All right,
let me
why don't
stop
you-
right there.
Questions, answers. Thank you.
I'm gonna stop right there and I'm gonna go into, we can actually show your body on camera, but not on this one. But what do you do specifically after taking in these observations?
I took notice to something in particular, which was a vehicle.
Why'd you take notice for that specific vehicle?
There was, it was in the on position.
Oh, stop you right there. Talking police talk. What do you mean the on position?
The engine was running,
Go ahead.
the lights were on. The car directly in front of the area that I was in. So it kind of drew my attention when I saw a person inside of the car.
Okay, let me stop you right there. Was there anybody behind the wheel of that car?
No,
Was there anybody in the passenger seat of that car?
no,
Did you see anybody at that time in the back seat of that vehicle?
yes.
Okay. Was that person sitting up?
Person was in a position that I was able to see them.
Okay. But were they sitting up as if they were in the seat itself?
No,
Okay. And could you see movements?
yes,
Did you know what those movements were at that time?
no.
Now, you see this. What do you do?
Once I saw the movement, the person, I walked over to investigate, see what was going on.
Now, let me stop you. Did you have your gun drawn?
No,
So you just walked over?
yes.
Go ahead.
Once I walked over there, I had my flashlight illuminated, and I indicated to come with me. Once I removed the pickle and the rear passenger, correct, the rear driver's side of the window, I observed the individual in the back seat. And
Now, wait. Was the door open at this time?
no, all doors were closed.
Okay. And tell me about the windows. Do you recall anything about the windows?
The windows were up. They were tinted. And I had my flashlight, so I was able to stand and illuminate the inside of the car. Pretty bright flashlight.
Okay. So you utilize your flashlight. What do you see?
I see the individual and a firearm.
Now, tell me about the position of this individual. Is he in a prone position? Is he lying down? Face
Yeah.
down?
The individual at that time was lying down,
Face up or face down?
face up.
Okay.
Underneath the individual's hip area, there was the handle of a firearm.
Now, I'm going to stop you right there because you say it's a firearm. How long is this interaction taking you?
Approximately.
How are you able to recognize a firearm in a minute or less, officer?
Because of my experience, my knowledge, been police officer for 7 years. I trained with firearms for more than that. I own a firearm. I had security training with licenses. I have a concealed weapon permit, so there's a lot of training off and on the firearms that I've experienced.
Okay. So happening within a minute. What do you do when you see this object that, based upon your training and experience, is a firearm? What do you do?
Well, once I see confirm that it's a firearm, at that point, safety kicked in. I wanted to then make sure that, for the safety of everyone that was on scene, public, myself, other officers, whomever was in the car, that whatever interaction we had afterwards was going to be peaceful. So at that point, I removed the firearm from that location.
And where did you grab it from? Or where did you remove it from?
Inside of the vehicle, on the person.
And what do you do when you recover that firearm?
Once I recovered the firearm was then passed on to another scene.
Do you know who that officer was?
Yeah, so it's Officer Harrell.
I'm sorry, one more time?
Officer Harrell.
Okay, thank you.
Now, after you pass off the firearm to Officer Burrell, what is your next step? At this point in time, what are you doing?
After the firearm was passed off, I tried to make contact verbally with the individual. Make sure that that person was okay. At that point, trying to create a dialogue, try to ask them certain questions. At that point, it was just interaction at that point to figure out, what's going on with that person.
So that's it.
Yeah.
You're just trying to figure out what's going on.
Yeah.
You're not making assumptions, are you, at this time?
No,
Are you putting your hands on it?
no,
Is your gun out at this point? You just
No.
saw a gun.
no,
Oh, are you, are you touching him in any way, shape, or form?
not at all.
So having just recovered a firearm, you're just trying to engage in a dialogue.
Correct.
Right. Now, at any point in time, do you hear the defendant make any comments regarding that firearm?
Yes,
And how did you come about hearing that?
it was, I was standing, he was seated in the vehicle, facing outward. I was standing in close proximity, and the question was asked to him in regards to the ownership of the firearm. And he made a comment that, which was, yeah.
So that, yeah, was a response to a question asked.
Yeah,
Okay, and what did you take that to mean at that time?
ownership. He was responding to the question
About whose gun it
about
was?
who's,
Now, I'm going to show, if I can. I'm going to show defense counsel what's been previously marked for identification purposes in 1A and 1B at this time. And Your Honor, I believe we have a stipulation with regards to this evidence.
All right. All right, so the item will be introduced into evidence, and what is that? Please advise. Please advise what the item is.
Oh, the item is the 2 CD copies of the body worn camera footage, and we're going to get into it with the officer whose body worn camera footage they are.
All right, without objection and stipulation by parties.
States 1A and 1B mark identification of states 1 and 2 with evidence.
Yeah, go to witness,
You may.
just so that you know. You recognize them?
yes,
And we've watched them before?
correct.
And tell me, whose body worn camera footage are we going to be doing today?
Myself, Officer Mendez, and Officer Howard.
In my hands, I have Officer Burrell and yours. Now, let's talk about your body worn camera. Let's talk about your body worn camera before we go into any the video itself. Are you equipped with body worn camera?
Yes,
Is the city of Miami police officers all equipped with body worn camera?
yes,
To your knowledge?
yes,
Are you trained in how body worn cameras work?
yes,
So you would know things like how to turn it on, how to turn it off.
correct.
How does a body worn camera function?
Functionality is, capture video footage once the on button is depressed and it starts recording.
It's the way you just described. Would you say it's a simple process?
It is,
Okay. Are you wearing it today?
no,
Why not?
because it's not required, once I'm off duty to,
Where's the body worn camera at?
it's dark, the police department.
So going back to your shift, you're a midnight officer. You go and you get on your body worn before you hit the road.
Correct,
Oh. Now, on October 16th, 2020, did you have your body worn?
yes,
Did it later come to your attention that that there was an issue with your body worn?
yes.
And what was that issue?
The function of, recording once I depress it is,
Sir, I'm so sorry. Your voice goes down a little bit. You are gonna have to keep it up. Okay, thank you. One more time.
Too deep down.
Yes, what I was saying is that, on that side, the function of it, being depressed, the power button, once I press the button on the camera, it did not, it gave the chime sound as if it was on, but it did not activate.
And you found this out later on.
Correct,
When you found out that your body worn camera was not activated, did you turn it on?
yes, I fixed the issue.
So we do have some body worn camera footage from you on the day of the incident,
Yes,
but it's just not the complete.
correct,
Let me phrase it like this, is your conduct and your actions of that night captured by anybody else with body worn?
yes,
So it's not like you were trying to hide what you were doing. You knew that you were being viewed by everybody else on tape.
correct.
This time, I'm going to put in exhibit 1 into the in-court Tinkler.
You're gonna turn it, you're gonna turn that.
Oh. Do you mind?
No, I have finished, yeah.
And we're gonna miss one. Yes.
Do you remember they used to put it back there?
We did, it was a lot better.
Yeah.
To do that.
Just a suggestion.
Oh, you're right. And Defense, if you need to move your seat,
Can everybody see the
you can move your seat.
Can you see the screen?
Okay. Robert, what we can do is actually, we can turn this camera just a little bit also. Yeah, yeah, a little bit like that. Even a little bit more. That'll work. Thank you. Okay.
Judge, maybe just go off the record real quick.
All right, we'll take a moment.
Thank you.
All right, you may continue, counsel.
Thank you, Judge. My apologies. Please come up this now. There you go. Now, officer, well, we're back on the record, Judge. May I
Yes.
proceed? Thank you.
Go ahead.
Okay, so officer, while my colleague is getting this set up, please tell me what we see on the screen. Go ahead.
At this point, the investigation, it's just, being conducted for an situation.
Okay. And is that, tell me this building right here at 35104, for the purposes of the record, is that the hotel?
Yes,
Okay. The blue doors, the second tier.
yes,
Now, I would ask you to stand up and come and point to for the white vehicle where you have to make quite a distant walk. In 35104, we also see what appears to be the hood of the vehicle you were referring to, correct?
yes,
And how do we know that's the vehicle you're referring to?
based on my recollection. At the event.
Okay. Do we see the lights on?
Yes,
Okay. Now, where are you in this video? Your Honor, you may.
Go ahead.
Thank you. Officer Roll, would you please approach?
But officer, you're gonna really need to, even if you feel you're yelling, okay, because we don't have a handheld
Do
mic.
I need to shout further, Judge?
No, you're pretty loud,
Oh, thanks, Judge.
and that's good. Officer Roll, you're more soft-spoken, so you're gonna really need to belt it out.
Okay, officer, now come here. Thank you. Where are you in this video?
that's the record.
And at this point in time, I want to go back over what you've already said, but what are you doing?
I'm just observing at this point.
Okay, now, your permission to allow him to stay here just in case, or do you want?
As long as the voice stays loud, that's fine.
All right. Go ahead, Ms. Burke. And if you know whose body worn camera footage is this?
This is, officer,
And for the record purposes, I believe we started at about 35104 on Officer Burrell's body camera. Zip one. And at this point in time, let's just state the mystery. This, what's going on, concerns the unrelated criminal matter.
Correct.
Okay. Now, I see a shining light. Is that the light we're referring to? I see it at 25236.
That's correct.
Okay. And what are you doing right there at 351, at 352:46.787? What did you do right there?
Remove a firearm from the
Keep going.
Yes, I removed the firearm from the vehicle from,
Oh, no, not too long, sorry, sorry. Go ahead, keep going with the video. Okay, stop. All right. So at this time, going back to what you said, you can't drop the firearm to someone else.
Correct.
What are you doing? Remember, this isn't your body on camera. Where did you go?
I was standing, in close proximity. Still observing at this point. Handed off the firearm and struck with, state. On query.
And what is the query?
Query is it's a check. Not a check.
The background check.
Yes.
What about making it safe? What do you mean by make it safe?
Disabling the firearm's functionality so it cannot be fired, making it safe to handle, making it, particular time.
When you touch the firearm, the cover, what does it feel like?
So, it felt like a firearm.
Does it feel like a pillow, a teddy bear? Oh. So it was a hard object being recovered.
Yes.
Now, describe to me the person you see in the back seat of this vehicle.
The male, laying back,
What's he wearing?
pants, no shirt, tennis shoes.
And do you see that person in the courtroom today?
Yes.
Will you please point out minor full clothing?
Wearing a black, varsity shirt with white dots.
Did that person later become known to you as the defendant's parents' table?
Yes.
And what was his? Sorry. And Your Honor, my apologies, I forgot to note for the record that the defendant has, the officer has identified the defendant.
So reflected.
Thank you. Now let's continue further. Now at this time, what does this mean like?
Still chaotic, person moving around,
People talking, you don't know what about. What's going on?
no.
What's your focus on at this time, officer?
The individual that was just removed from the vehicle.
Does every police officer have a role on scene?
Yes,
So for example, you don't all go and cover around the firearm.
No,
Okay. What do you do with that? If somebody else is doing the firearm process, where does Officer Roll go?
go ahead and I assume something else that someone is doing, which is either speaking with victim, subject, paying attention to certain details that someone else may not be attending to. It's an overall duty of an officer to pretty much cover any loose ends that another officer may not have the opportunity or may not see.
So would it be fair to say that you're all doing different things?
Within task.
Okay, and your focus might be on something that Officer Burrell may not be focusing on.
That's correct.
Now, as we're continuing to watch the video, where are you at?
At this point, I'm still in the area where the individual is at.
Okay. Okay, please stop the video. All right, Officer, stand there, and we're gonna put you on. Or you know what, I don't think you're needed. Go ahead, back and sit down. Leave it up here with us. You know, can you please put that up? Officer, my apologies, I'm gonna ask you to step back again. Okay? Can you just put it up to the position when he walks over to, when he walks over to the car? Thank you. I just realized I had to explain on the stand, you know, where the gun is. But I would like to open it up to the actual video portion and have you demonstrate to me where it was, or show the jury on the first. And we're going to, I will rotate it for the record. Oh, stop it. Thank you. That's a before it becomes so quick. All right, so tell me what you see at this instance.
In this instance, I see the firearm on the subject's
Yes, you may point.
neck.
And that's at 3:52:43 in the video. We're still on exhibit 1, Officer Burrell's body. So you're the one closest to them.
Correct.
And just briefly go forward, good stuff. At what point are you able to get a better view of the firearm?
Once the inside of the vehicle was illuminated and the door was open, there was a point in time where he was shifting around. And as he was shifting, the firearm became more and more evident that it was the firearm.
Okay, it's okay. I would like to stop a break. Here. Officer. When you say more evident, is this the point in time where it became more evident at 3:52:45 in Officer Burrell's video?
Yes.
Now, please describe to the jury. I'm not sure, but I'm not going to assume. What's the backseat of the car look like?
It's soft, it's flat,
Does it have a back?
it's a back.
Okay, so in relation to the back of the car, where was the firearm recovered from?
Underneath
Go ahead, sir. Go ahead.
underneath his left hip. You see, he lifts his leg so it became more transparent.
Go ahead, play the video. So, at that point, the firearm is located closest to the back seat, near the crevice of the car.
Yes.
upper hip.
Yes.
So I don't know about you, but I can't see it in that vantage point. Why is that?
Well, every camera angle is different. I'm on scene, my depiction of what I see in terms of whether it's shown on the camera, whether it's audio or visual, is going to be different from that perception while they're on scene.
Okay, so, you know, at this point in time, did you go back to see if your body worn had captured that moment? Your body worn, had your body worn captured that moment?
But no,
No, okay, because at that point in time, it still wasn't on, and you didn't know it.
correct.
Go ahead and have a seat, thank you very much, I appreciate it. All right, at this point in time, we're going to take out CD one. You're going to go ahead for the record, including exhibit two. And please put it on. Thank you. Okay. Please put it on. Just do it, just in case, double safe. Okay, thank you. All right, officer, now, we're looking at exhibit two for the record, timestamp, we're looking here, ladies and gentlemen, 3:54:02, just so everyone knows what I'm talking about. All right, now, what do we see from the vantage point of your body?
What we see is now myself observing the individual in the backseat of the vehicle.
Okay, does this come after you recovered the firearm?
It's out there, yes.
Go ahead. Officer, who is that female who appears at around 3:54:48 in the vehicle with the blue gloves on?
That's Officer Moses.
So Officer Moses was on scene too.
Yes.
Officer, there's somebody who's talking to you at this time. And it's at 3:55:25. Do you know who this person is? Objection, motions in the
Sustain.
No, Judge, can we please go step back? Officer, do you observe picking up where we left off at 355.5 on exhibit 2, Officer Wool's body worn camera? Do you observe a woman on scene with a black cap on and a black outfit on?
Yes,
Do you observe her speaking with the defendant?
yes,
Now, you observe her speaking with the defendant multiple times, not just one time?
yes.
Okay. Well, and at some point in time, you'll tell me what she said to you, but you engage in conversations with her.
Yes.
Okay. Officer, what is she doing in that scene?
He's,
Can we go back, please? This is about you. What are you doing? You're following this woman.
right. She's retrieving documentation from the vehicle,
What documentation is she retrieving?
the defendant's information.
Now, keep going. Please, Jennifer, my apologies. And just for purposes of time, we are planning the entire 30-minute portion of this body. Let's stop right here. Officer, we just watched from the beginning, about 357:08. At any point in time, have you put your hands on the defendant?
No,
Did you physically remove him from the vehicle?
no, I asked.
Were you banging on the vehicle?
No,
You banging on him?
no,
Sorry. Oh, you know what? Stop. Take that back. At this point in time, is he being held by anybody?
no,
Where is he at now? So we're looking at 357:11 in the exhibit 2. Where is he at?
he's seated on the front hood of the vehicle.
Keep going. I'm going to stop the video at 3:50:27. Officer, what's his demeanor like with yourself and the other officers on the scene?
Angry, belligerent, argumentative. That's kind of just giving us a hard time working.
You're putting it nicely, officer. You know, was he using any type of language towards you?
Yes, we were using profanity, derogatory terms. going-
Now, in response to that, did you pull out your gun?
No,
In response to that, did you raise your voice to him?
no,
Did anybody on scene, to your knowledge, raise their voice?
no,
Did anybody on scene remove him?
no.
Overruled.
Please. And at this point, are you just doing your general duties, speaking to civilians, making sure, making sure you're being thorough in your investigation?
Yes,
Okay. At this point, what's the defendant doing as you're continuing to observe him on scene?
continuing the same pattern of the attitude, continuously name calling. Actually was targeting this specific officer for some reason.
And who is that officer?
It's sustained.
But there are other officers on the scene.
Yes,
And also, if you don't mind coming up and, please, Commissioner, Your Honor, can you please come up and point to, the defendant on video, please? I don't think I can do that.
You may, sorry.
Please stop the video, Ken. Ms. Garcia,
is, the defendant.
thank you. Go ahead. I'm sorry for the long. Go ahead, keep going. Marisa. I just want to make sure because it is a bit of a long video, if everyone can see it. There's some portion that goes in and out. All right, officer, at this point, you don't need to stop it. We're into about 403 of the exhibit 2, your body on camera. At this point in time, has anybody touched this thing?
No,
Where is the position at?
now still on the hood of his vehicle.
Now, as an officer, what are you doing at this time? You're seeing this. What are you trying to do to help this situation?
Trying to maintain my composure, speak to him, if I would speak to him, normally, trying to resolve the issue. And, how the resolution that's gonna come out of it, accomplish that.
So at this point, have you made any assumptions?
No,
Can you please go back, Bruce? Or Ms. Garcia on my phone? Play. Stop. Oh. Stop. It's very difficult to see, but in the bottom left-hand corner at 405:46, officer, what is that we see?
that's the firearm that was removed from underneath the, subject, the defendant in the vehicle.
And at this point, it doesn't look like the same way when you recover it, does it?
No, it's, at that point, it's been made to be called safe.
We're going to forward it by one here. I think we're about done with the body on camera, because if you could just tell us, what's the rest of this body on camera going to show?
It'll show me continuing to observe the vehicle from the outside. It'll continue to show the interaction with the defendant, his behavior. It'll continue to show other interactions with persons on scene.
Okay, and at this point in time, you're gathering information,
Yes,
right? You're gathering information so that you could find out crime was committed and who committed it. Is that correct?
correct.
Please, I know it seems boring, but this is what you're doing during this entire period of the time.
Correct.
And there's about a good, 15 minutes left of this.
Correct.
Okay. So you're not just jumping the gun.
No, ma'am.
Okay. Now, I just want to briefly go back to the firearm. The firearm in this case was found, you said, underneath the defendant.
Correct.
Was it readily accessible to his hands?
Yes. It was. His hand was actually positioned next to his side, his left side. That would made me even more, or made it more of an urgency to extract or remove the firearm from the vehicle. Because, like I said, for everyone's well-being on scene, as well as the defendant, you don't want anything to escalate, just being safe. So,
And I think the video speaks for itself, but the firearm was not in a locked box or,
it wasn't
glove
plain view.
compartment.
It wasn't plain view. So,
And Judge, at this time, the state is going to move to admit what's been marked for identification as 1C for the stipulation of the parties. It's Officer Moses' body worn camera, a brief clip.
No objection. All right, with stipulation, no objection, admitted.
One C mark, I think, let's see, 300.
Please do that to the maximum. This is sound. Now, is there anything else that you did on scene that night before you determined that a crime was committed and committed?
no,
Did you write any reports or do anything afterwards?
no,
Did you assist anybody with writing any reports?
well, as a training officer, I monitored Officer Moses.
Okay. So she wrote a report in this case. And you do advise her everything that you had heard on scene
Yes,
and everything you had seen on scene.
that's correct.
Now, what about footage from the hotel? You're the field training officer. Did you go and collect footage from the hotel?
I did not.
And why is that?
Unrelated.
And from your vantage point, would the hotel have captured who was in possession of that firearm in that car?
Objection, speculation.
Overruled.
Go ahead and answer.
No,
All right, now, before we finish your testimony, Mr. Rule, I want to go back to the portion where you heard the defendant respond to whose firearm it was. Can you please go? We're at 353. Officer Roll, is that the portion, is that the specific period of time, 353, 36, and some seconds earlier, where you heard the defendant say, yeah, yeah?
yes, that's when he responded to the question. Yeah, yeah.
Just a brief moment to confirm. Thank you very much.
Thank you, Cross.
Oh,
Counsel, I'm sorry, if you want to move, turn the podium a little bit. That way, that's good. And again, speak nice and loud into the microphone. Thank you, sir.
Okay, no problem. All right, Officer Roll, so you testified today that at the time that you approached the car, you thought your body camera was active.
Repeat the question?
On direct, you testified that your body camera had not been activated when you first approached the white car.
That was found out. Yes.
And you testified that at the time you approached the white car, you thought your body worn camera was active.
Correct.
You hit the button.
At which point?
When you were supposed to activate the body worn camera and you bid on scene, you hit the button.
Right. Initially, once I arrived to the call, I depressed the power box.
And you heard a chime on the body worn camera.
Correct.
And then at some point later, you realize it's actually not recorded.
Correct.
And so to be clear, it's your testimony today that your body worn camera was not activated the entire time you were on scene.
Correct.
Today is the first time you've ever said that under oath.
You're asking, repeat the question?
Today is the first time that you've said under oath your body worn camera is not activated throughout the entire involvement in this case. Is that right?
Can recall.
Well, I imagine you recall that you gave a deposition in this case.
Yes.
Give me a page number, please, that you'd be referring to.
Yes, Your Honor, it's page 8, lines 11 through 16.
Objection, Your Honor.
What page, please?
8.
Improper impeachment.
Sustained.
Is there anything that could refresh your recollection about your previous testimony?
Objection to the form of the question. Reference to testimony.
Rephrase your question, please.
Officer,
Start with the question again.
today is the first time you've ever said that your body worn camera was not activated. Isn't that right?
And the answer was to that already, he cannot recall.
So do you recall testifying in this case previously?
That's the final.
You gave a deposition.
Yes, deposition.
It was on January 26th.
Objection, improper impeachment, Your Honor.
Sustained.
With reviewing the transcript of your deposition, refresh your recollection about your previous testimony with respect to whether or not your body worn camera was activated.
Yes.
And approach on it.
Chuck, you know what it is. You already showed it to you, right?
No,
Oh,
you did not.
go ahead.
Okay, now, Mr. Rowe, I'm going to direct you to lines 11 through 16. Just read those to yourself.
Don't read them out loud, sir. After you read them, let us know if your recollections are fresh.
Yeah.
Overruled. Ask a question, sir,
Officer Rowe is
please.
reviewing the deposition transcript from fresh recollection.
Yeah.
So you previously testified that the body worn camera was on the entire time.
Overruled. Move along. Can you answer that question?
Prior to, prior to me viewing or reading any of my notes,
And so on direct, you testified that Mr. Davis made a statement.
Yeah.
And he was asked about the firearm, and it was his, and then he said, yeah, that was your testimony, correct?
Yeah.
And we can agree that that part's not on your body worn camera.
not on my calendar.
It's on someone else's body worn camera.
Yes.
You know in this case that there are no fingerprints that were tested on the gun.
My knowledge, I don't have that information.
You have no knowledge of the gun being sent to the lab for DNA test.
No,
So you would agree that if there was something like a confession, that would be pretty important evidence.
part of it.
When he's asked about the gun, he's still in the backseat of the car.
Yes,
You testified on direct that there were numerous people.
I'm not understanding the question.
On direct, you testified that on scene around the car, there were numerous people.
Not sure what I said exactly.
I'm not sure what you said on direct today, that there were numerous people around the car,
There was officers,
and there were also civilians around the car.
based on the body camera, I thought there was officers around the car.
You testified on direct that it was chaotic.
Yeah.
And that people were arguing.
Yes,
And so it's when all of this is happening that Mr. Davis is in the back of the car.
yes,
And that's when he's asked if he owns the gun.
yes,
When you hear what you said as his response, you don't then ask him to repeat himself one more time.
do I ask him to repeat?
Correct. You did not ask him to repeat.
No,
You didn't have him say it more loudly so that it could be heard on the body cam camera.
no,
Speaking with witnesses is a pretty common part of your job.
correct,
And speaking with suspects,
correct,
you have statement forms.
Objection, relevant.
Overruled. Go ahead, counsel.
You can have a suspect fill out a statement.
yes,
You have pens,
yes,
and in the past, you had suspects write a statement about what happened.
Objection, relevant.
Sustained.
Here, in this case, there's no written statement for Mr. Davis.
no,
And other than the clip that we saw in direct, there's no other time when the other said that was his gun.
No. No.
Okay, so let's back up. So you arrived at the motel and it's early in the morning, right?
Yes.
It's 4 in the morning.
Approximately.
And as we already said, there's officers near the car.
Yes.
They're talking.
Yes.
They're talking to civilians.
Yes.
And the civilians are also talking back.
Yes.
And this is all taking place right in front of the car.
Somewhat.
You agree, they're pretty close to the car.
Yes.
And eventually, like you said, you open the door to the car.
Yes.
And Mr. Davis, he's laying down.
Yes.
Officers then try to wake him up.
Sustain.
The officers start to hit either him or the seat, right? They go like this.
No.
Objection.
Sustain, counsel.
Sidebar.
Continue with your questions, sir. You can reserve.
This time we're going to play a clip from Officer Mendez by camera.
Is it from one of the documents that have already been admitted?
Yes, I'm going to look at which one it is.
All right.
I'm just after the order for the record.
Mhm.
No, I just need to figure out which. Tell me which. Or- The record will be playing Officer Moses' body on camera, 3:53:05 to 3:53:20.
I'm sorry, three what? Three what?
3:53 and 5 seconds to 20 seconds.
Very well. Someone want to assist?
You can go off the record, it may take a minute.
Back on. All right, counsel, are you set up?
Yes, Your Honor, I'm just getting.
Okay, that's fine.
Okay, so Officer Roll, what's going on here is that Mr. Davis is still in the backseat of the car, right?
That's correct.
And so there's an officer you can see, and he sort of has his arm reached out, and it's a little bit through the doorway of the right here, this officer's arm is sort of into the doorway of the car, right?
Yeah, that's really.
Do you want to come over here and take a look?
You can stand down, sir.
You can see the arm right here, right? And sort of extended from the door of the car.
Counsel, I'm sorry. You're gonna have to keep your voice up if you have a
Thank you.
question. Thank you.
So you can see that officer's arm is extended from the open door of the car, right?
Not there.
Okay, well, let's see. Watching the video. we'll take a little more. So, you hear that sound that? Are you able to hear that? Do you hear that sound? Right. The officer is bent over, sort of halfway through the door of the car, right? You hear that sound? Yes. Okay, and so Mr. Dade is still laying back, right?
Yes.
Okay, you can have a seat, also, I think. So when Mr. Davis is woken up, as you testified, he's upset, right?
Repeat the question?
When Mr. Davis is woken up, he's upset.
Objection, it seems
Sustained.
that's not evidence.
Sustain.
When Mr. Davis gets out of the car, he's upset.
Yes.
He was slow to sit up.
He was slow to sit up. He sat up.
He doesn't sit up right away.
It's, to me, it's an opinion. I can't even tell if it was fast or slow. I can't really answer that.
Okay, well, when you open the door of the car, he doesn't sit up.
No,
When you pull the firearm out, he doesn't sit up.
no,
When he does sit up, he lays his head up against the door to the car,
at some point,
and he puts his head in his hand.
some point.
From your observations, it seemed like you've been drinking.
Objection, it seems that's not evidence.
No testimony about sustain.
Based on just your observations from the demeanor, from the context, was he acting like someone who's been drinking?
Objection, it seems that's not evidence.
Sustain.
We can agree that this is a hotel parking lot
Yes,
at 4 a.m.
approximately.
He's in the backseat of a car
Yes,
with no shirt.
yes,
When you retrieve the firearm, you don't get it from inside of his waistband.
no,
His hand is not around the firearm.
more specific.
He's not physically holding the gun.
No,
The gun was not in his pocket.
no.
It was not in his sock.
Repeat that question.
The gun wasn't in his sock. It wasn't coming out of his shoe or
You
anything
said
like that.
sock. Oh, no,
So you've been with North Miami Police Department for 7 years, is that right?
yes, approximately.
And they have crime scene investigators.
Yes,
Officers can request that investigators come to the scene of the crime.
Yes,
They can check for fingerprints
yes,
or swab for DNA.
yes,
And your police department can also send evidence to the lab,
yes,
and the lab can test for fingerprints
that's correct,
or swab for DNA.
correct,
And you have a form you fill out if you want that to happen,
that's correct,
a lab request form.
correct,
On the form, there's a section for fingerprints
correct,
and for DNA.
correct,
You just have to check the box.
exactly,
And then if you check the box and fill out the form, the item's tested for fingerprints.
correct,
This Motel 7, you've been there before.
I have,
And as you testified on direct, they have surveillance cameras.
Objection, also, one more question.
No, overruled.
The surveillance cameras at the motel are not of the inside of the room,
Are not what?
not of the inside of the motel.
Objection, speculation.
If you know,
The cameras are outside of the motel rooms.
I've seen cameras outside,
The cameras don't face inside of the rooms.
know where the camera's face.
From seeing the cameras, they're angled toward the parking lot.
Know how the camera's angled, sir. I didn't install them, I have no participation in the construction of the building. I can't answer that question.
Okay, so you didn't check if the cameras were facing the parking lot or for the white car. That's not something you do.
So,
One moment.
sure.
So will you search inside of the white car at some point?
No,
You never searched inside the white car.
no,
You also never saw any documents about the car.
Objection, relevant.
Sustained.
You never saw anything that said Terrence Davis is the owner of the car. That's not something that you saw.
Objection, motion to eliminate.
Sustained.
Officer, to be clear, the incident your dispatch for is not something involving Terrence Davis.
Objection, motion to eliminate relevance.
Sustained. Sustained.
Pretty common that multiple officers will respond to a dispatch.
circumstantial,
Is that a yes? Multiple officers normally respond to dispatches.
and under a call, in the call.
But there's plenty of calls where multiple officers respond, right?
Yeah, officers respond depending on the contact and numbers or if you get sent an officer, depends on the call.
When multiple officers respond, there's always a lead officer.
Correct.
The lead officer in this case is Officer Moses.
In this case,
Typically, it's the lead officer who would fill out any lab request paperwork.
yes,
Officer Moses is being trained
correct,
by you.
correct.
That only lasts for about 16 days, right?
Objection, relevance.
Sustained.
If anyone would have asked for crime scene, for fingerprints, it would have been Officer Moses.
No,
And to be clear, Officer Moses was the lead officer, right?
I just call yes.
No further questions on that.
Any redirect?
Yes, Your Honor. Thank you.
Mhm.
Also, while my colleague is assisting me with that, graciously, let's go ahead and get into redraft. Okay. Now, defense counsel asked some questions about possession. Excuse me? No sound, correct. And my apologies for speaking out of record. We're putting in CD one or exhibit one into the CD player, or we're playing with no sound. Officer, there was a lot to do about your body worn. It looked like there was a lot of dead time. Was there in reality a lot of dead time?
No.
Okay, what are you doing during that period of time? Before in direct, you mentioned you're running queries, which we determined that to be a background check.
Correct.
Are you running background checks on just the gun?
No.
Okay, are you running background checks on the defendant, Terrence Davis?
Yes.
Okay, does it come to your attention that the defendant is a convicted felon?
Yes.
Okay. Now, under the law of Florida, can a convicted felon possess a firearm?
No.
Okay. So at this point in time, do you care whose car it is?
No.
Do you care who even owns the firearm?
No.
Do you care who possesses the firearm?
Yes.
Okay. Now, and how long does one have to possess, a convicted felon have to possess a firearm for? To be,
Sustain.
does it matter how long he possesses it for?
No.
Sustain, excuse me, strike the response.
So is it true that you don't have to own it, you just have to possess it?
Objection, legal conclusion.
Oh,
Correct.
That would be a fair and accurate statement. Okay. Let's go to the video portion. Please move forward to where we're at the video. Yes, we're at the clock. Okay, thank you. Thank you, stop right there. At this point in time, who is in the vehicle?
Defendant,
Where is the gun?
his hip, left hip, and
Who has the gun?
sustain.
Is there anybody else in that car who's possessing that gun?
no.
And when asked whose gun it was, the defendant said, yeah.
Correct.
Why did you take a photograph right then and there, Officer Wolf, of that firearm?
It was on body cam. So the necessity, the importance of me taking the footage versus the safety of everyone else on that scene, and the possibility of, that firearm being used against anyone on the scene was more important.
And why were you so concerned it would be used? Where were the defendant's hands at that time?
Sorry,
And is that where the firearm was found?
that is correct.
Now, why didn't you stop right then and there and call out crime scene?
It was not important. That was optional.
Okay, and then since everyone saw it, there was so much downtime. Why didn't you call crime scene then?
At that point, we were still investigating. Trying to,
Was the firearm in the same spot?
no, at that point it was safe. It was removed and
Would it have been appropriate for you to pick up the firearm and go put it back in the vehicle?
no.
Now, what about You were asked to come up and demonstrate, talk about what other officers are doing on the body worn. Officer, did I ask you during direct to talk about anybody else's movements on scene?
No,
Whose movements can you testify to?
my own,
Now, let's get to DNA. Officer, you're an officer. Doesn't matter if you're the lead, doesn't matter if you're assisting. Can anybody fill out those forms?
correct, anyone can fill out, form and send in an application.
Okay. Now, why didn't you fill out a form in this case?
This particular case, it was deemed unnecessary because it was, visual by myself, because I was actually there, and the subject was actually seen in possession of the firearm.
Officer, would it have mattered if somebody else on scene, because there are multiple civilians on scene, would it have mattered if they had touched the firearm moments before?
You know,
Sustain.
Officer, for purposes of your investigation, why didn't you take the DNA and fingerprints in this case?
because in this particular situation, that was not necessary.
And why wasn't it necessary?
Subject was seen in actual physical control. possession of the
I,
firearm.
stop. When there's an objection, you stop for a minute. All right, the objection is overruled, but I also need you to keep your voice up in your response.
And why didn't you? Short and simple, why didn't you?
You were seen with the firearm in possession.
Thank you.
Thank you, sir. You are excused.
Oh, Your Honor, may we just go, just briefly, I don't want to excuse this witness unless we know he's needed.
All right, hold on. Thank you. The witness is excused, sir. How's everyone doing? Okay, need a quick break? All right, ladies and gentlemen, I ask you to leave your notepads at your seats. Please do not discuss the case. Robert, can you take them outside?
Sure.
We'll have you back in a couple of moments, all right? Get a drink of water, stretch your legs, and use the restroom. We'll have you back shortly. Thank you.
All right, for the juror.
this is the rest, planning for the rest of the afternoon, finish with Officer Carroll, and then take a break, or are we gonna go straight to closing?
We're not gonna go straight to closing. You're gonna have lunch and they're gonna come back for closings.
And that's-
But there's several things that I need to do before we get to that point. So I don't know if the defense is gonna present
That's correct.
any witnesses or if Mr. Davis wishes to testify. We gotta do all of that. So let's, as soon as you rest, we'll reassess everything.
All rise on the doors.
All right, everyone, please be seated. Thank you. All right, welcome back, ladies and gentlemen. We're ready to proceed now. State, call your next witness, please.
Very good.
Please step forward, face the clerk, raise your right hand and be sworn.
You solemnly swear affirm testimony about to give the truth, the whole truth, and nothing but the truth, sir? So you can be seated.
Come on over here and have a seat. Thank you. Please keep your voice up, loud into the microphone. Thank you.
Your Honor, may the witness remove his mask if he's comfortable.
That's fine.
The officer. Thank you for being here today. Can you please state your full name for the record?
You're gonna need to keep your voice up, counsel.
Understood.
Much louder than that. Thank you.
Can you please state your full name for the record?
Officer Tavino,
What's your occupation?
police officer for the city of North Miami.
The city of where?
City of North Miami,
How long have you been an officer with the city of North Miami?
Oh, and careful with that mic. I mean, loud, but if you get too close, it makes those funny sounds. All right, thank you, sir.
I'm welcome.
Mhm.
2 years, you said.
Yes, ma'am.
What sort of training did you have to go through to become an officer with the city of North Miami?
Went to the police academy for approximately 6 months. After that, there was another month of in-service training, and it's about 4 to 5 months of that field before I got on the road. I'm off.
Do you have any previous law enforcement experience?
No, ma'am.
Any other type of security training?
No, ma'am.
What is your current assignment with the city of North Miami Police
My
Department?
current assignment right now is road patrol.
What do you do when you're assigned to road patrol?
Assign a specific zone for that day and whatever calls for service that we say. That's assigned to that same day list.
So every day when you go in, you get assigned to a specific area of the city of North Miami?
Correct.
Now, I'd like to focus on the reason why we're all here today. Were you working as a police officer in the city of North Miami on October 16, 2020, at approximately 3:30 a.m.?
Yes, ma'am.
Are you usually on duty around that time?
Yes, ma'am.
What's your shift?
I work overnight shift
Overnight, starts at what time?
from 11 p.m. to 9 a.m.
Okay. What area were you assigned to on October 16th of last year, 2020?
I can't remember exactly what zone I was assigned to that day.
Did you at any point during your shift that night respond to 13445 Northwest 7th Avenue, North Miami, Florida 33168?
Correct.
And Motel 7,
Yes, ma'am.
is that in Miami-Dade County?
Yes, ma'am.
When you responded to the Motel 7, was there light? Was it dark?
No, I'm sorry.
I'm sure the power always is around 3:30 a.m.
Correct.
Was the area that you responded to, particularly the hotel, well lit?
It was
Was it raining?
okay.
Later during that night, after you responded, night morning, on October 16, 2020, did you come into contact with an individual who later became known to you as Terrence Davis?
Yes, ma'am.
Do you see that person in the courtroom here today?
Yes, ma'am.
Would you please point at him and identify him by an item of clothing? You can move around.
Right there, the top of the shirt.
Let the record reflect that the witness has pointed to the defendant and identified him by an article of clothing.
So reflected.
Officer Harrell, how did you first come in contact with the defendant?
Came in contact with him when the officer rolled, flashed his light in the vehicle. And that's how myself and officer rolled in contact with him.
Okay. From Officer Roll's testimony, it is my understanding that you were there investigating.
Overruled. Ask
You were
question.
there investigating an unrelated incident, not related to the defendant.
Correct, yes, ma'am.
When Officer Roll flashes light at him, let's go over what happened then. What did you see Officer Roll do?
Seen him flash a light in the vehicle. Seems to be something of someone laying down in the back of the vehicle. And officer roll approached the vehicle and I was behind him.
Officer, I am going to show you what has been previously introduced into evidence as State's Exhibit 1. Can I have permission to position myself?
Yes, sure.
Everybody can see the TV. For the record, I am now showing timestamp 3:51:33 from Exhibit 1. Officer Harrell's body movement. Officer Harrell, as you're standing right here,
Yes,
is
ma'am.
this before or after Officer Roll saw the defendant?
This is before.
Is it?
Have you come into contact with the defendant then at 3:52:27?
No,
Is this when you came into contact with the defendant?
yes, ma'am.
I'm sorry, I didn't hear your answer, sir.
Yes, ma'am.
Thank you.
You're welcome.
What does Officer Roll do there at 3:52:45?
That's when he takes a firearm from up under the defendant and puts it in the back of the vehicle.
What are you doing right there, 3:53:01?
Right now, I had taken the firearm, I made it safe, clear, and empty, because the firearm was loaded. And for my safety and my safety, other officers and anybody around, you don't want to have any projectile on the firearm. So say you have an accidental discharge or somebody taking a firearm and possibly somebody.
When you say made it safe, what does that involve?
Basically, I actually took the slide of the firearm, took it back, put the slide lock up. Now, and after that, I'm sorry, at first I depressed the magazine, to take the magazine out. Move the slide lock back as you can see right now, and to take the live round out of the chamber.
So there was a bullet in the chamber.
Correct, yes, ma'am.
After you made it safe, what did you do?
After I made it safe, I actually went to a protection or information channel to actually run the firearm to make sure that it wasn't stolen, what we call a complete check.
Okay. Do you remember what type of weapon it was?
Yes, it was a black Glock 19.
Is that a revolver, semi-automatic?
That's a semi-automatic pistol.
How were you able to tell that it was a Glock?
I actually have the name on the side. It's a Glock 19 by 19. And I actually have the serial number on the side, on the slide, which I can't remember the serial number for.
Would anything refresh your recollection?
Get a copy of the property.
Joe, what's it?
May I approach you with this camera? What was the serial number on the weapon?
WHT 896.
Officer, what makes a semi-automatic different from a revolver? Do you know?
Yes, and revolvers, they have a cylinder as in a circle. And semi-automatic weapons, they don't have a cylinder, has an actual slide. Revolvers, they're either 5-shot, 6-shot. And with semi-automatic weapons, you see the magazine right there. They have from 10 to various amount that you can store inside the magazine.
With a revolver, let's say you have a loaded revolver, you pull the trigger, a bullet comes out. What do you need to do to make the revolver fire again? Do you have to pull back?
That depends if it's single, if you actually place a firearm in single action only, but if it's double action, just keep the person on the trigger.
So with this firearm that you found that day, this Glock 19, you could pull the trigger, bullet comes out, you can pull the trigger, another bullet comes out until you run out of bullets.
Correct.
Can you tell me what happened with the gun after you made it safe? You called dispatch and you ran the gun through the system.
Yes, ma'am. Basically, after this entire process from making the safe plan empty, getting the results of the complete check back, the firearm was actually placed into a vehicle, a police vehicle.
And let me stop you right there, officer, I'm
Yes.
sorry. What is the purpose of you calling in the firearm, description of the firearm, the serial number? What are you looking for?
To make sure that it's not stolen.
Okay. Now go ahead. You put it in your bag, you said?
At that moment in time, a lot of officers, especially after we have manila envelopes, and this is for storage department from any type of scene. So it was placed inside of an envelope. The only thing I'm not sure of if it was stored in my vehicle or the lead officer Moses' vehicle.
But at some point, it never left the police's
Oh,
custody.
no. Not really.
And at some point, either you or Officer Moses or Officer Wolf or another officer that was on scene would have done what with the weapon?
As soon as we place the firearm inside the vehicle to have it secure, because you don't, and lock the vehicle so it won't get back out. And then after that, once we went to the station, it was impounded at the North Miami Police Station.
Okay, going back to you running a check on the firearm and then briefly, When you do this, you just said it was to make sure it wasn't reported stolen.
Correct.
Do you also make sure that it hadn't been previously used in another crime?
That, for that part, I wouldn't get that part back from just a complete, I'm sorry, from a complete check.
Do you run a check to find out who the owner is?
No, that information will be accessible.
Okay, so after you put the firearm in the bag, you secure it in the car, you drive it over to the station, and you walk me through, you said impounding. How do you do that?
In the process of impounding, sure. But basically, you take some zip ties as the start of the firearm is placed back. You'll see a zip tie placed from the barrel through the slide, and just for safety, even through the magazine up to the slide, just to make it safe, clear, and empty. Once that process happens, it's placed in like a clear bag, which is sealed. The firearm is stored separately from the actual magazine or live ammunition. And
I would like to now show the witness what has been previously marked for identification as states 1D. I believe there's a stipulation. Without objection, Your Honor.
All right, without objection. Thank you.
May I approach the witness, Your Honor?
Mhm.
Officer, is this the zip tie that you were talking about?
yes, ma'am.
Why do you place that around what is this, a chamber?
Yes, ma'am.
And this is
So that-
the barrel. Why do you place that from the chamber out through the barrel and around?
Because you want the weapons to always be safe, clear, and empty.
Does having this type around the chamber through the barrel prevent the slide from being racked back?
Correct.
Would it prevent anybody from inserting a bullet into the chamber?
Correct. Yes, ma'am.
Okay, officer, so you recognize this weapon, correct?
Yes, ma'am.
Is this the weapon? Is this the weapon that you recovered from the scene on October 16th, 2020?
Yes, ma'am.
Is that the weapon that we see right here at 35349 being placed on top of the vehicle?
Yes, ma'am.
How do you know it's the same weapon?
Different stripes, I said the exact weapon that I have, made a complete check on. It's about 19 by 19, and that serial number is WHD 896.
Okay. Can you see anywhere in this firearm where it says that it's a Glock 19?
Yes, right, it's about 19.
Okay. Can you see the serial number?
Yes, the serial number.
Can you please read the serial number?
Yes, WHD 896.
And that is the same serial number as the weapon that you found on the scene that day, correct?
Yes, ma'am.
Okay. Your Honor, at this time, I would like to offer what has been previously marked for identification as states 1D into evidence.
Any objection?
No objection.
Very well, without objection. No, you don't need those.
State 1D marked for ID on stage 4 and FX.
For purposes of the record, I am not cutting the clear plastic bag of a gun is in place. This is a gun you found. Right, can you touch it? Feel it? You can pass it around, it's being safe. There are no bullets.
Are you asking a question of the witness?
I will not. Officer, along with this weapon, did you find anything else?
Yes, along with the weapon, there was a magazine, a holster, some ammunition.
Magazine, a holster, and ammunition. How many rounds?
Approximately 15 rounds.
Was the magazine empty, full?
It was full to capacity.
Okay. I would like now to show what has been marked, previously marked for identification of states 1E to the witness. Officer, what is this?
Actual projectile code,
What is this?
more projectile, more bullet.
Please refer to the identification number.
There are, it's a composite 1E. Your Honor.
Composite 1E, all right. thank
Yes.
you.
What is this?
There are more bullets in the actual magazine and stuff.
And this magazine goes into this right here.
Yes.
How do you know these are the same items, same bullets, same magazine that you recovered that day from the scene?
It came from the magazine, but actually the reason why it's separate because they have different manufacturers. Is that all of them have
What do you
millimeter?
prefer, counsel? I am now showing the officer 1 of 5 in composite exhibit 1E. This the magazine?
Yes, ma'am.
Those bullets, were they inside the magazine?
Yes, ma'am.
I am now showing the officer what has been marked as 2 of 5 in states composite 1E. Are these bullets?
Yes, ma'am.
Are these bullets that you found that day?
Yes, ma'am.
Were they inside that magazine?
Yes, ma'am.
I am now showing the officer what has been marked as 3 of 5 of states 1E for identification. There's a bullet
Yes, ma'am.
that you recovered that day
Yes, ma'am.
that was inside the magazine,
Yes, ma'am.
showing 4 of 5 of composite 1E for identification, another bullet
Yes, ma'am.
inside the magazine.
Yes, ma'am.
The state would not like to offer what has been previously marked for identification as composite 1B as evidence without objection.
Without objection.
State 1D marked for ID on stage 4.
Officer, you testified earlier that when you were made in charge of this firearm, you made it safe. When you made it safe, did a bullet come out of the chamber?
Yes, ma'am.
Was there a magazine inserted into the gun?
No, ma'am.
You removed the magazine,
Yes, I remember.
Right,
the magazine.
okay, but as you found it, it had a loaded magazine and a bullet in the chamber.
Correct.
Does it then have a safety?
No, not on that particular gun.
Can you say that this gun, as it was found that day, was designed to expel a projectile by the action of an explosive?
Correct.
In other words, if, as you found it, as Officer Rowe found it, somebody would have taken a gun and pulled the trigger, would a bullet have come out?
Yes, ma'am.
More so, if after you made it safe, you would have gone back, put a bullet in the chamber, released a slide, and pulled the trigger, a bullet would have come out.
Yes, ma'am.
You would say this is a functional firearm.
Yes, ma'am.
Is this an antique?
No, ma'am.
What's happening now? Officer, would you say this gun is a toy?
No, ma'am.
No questions now.
All right.
Just inquire with the defense counsel, if we need to remove the lines.
That's fine if you want to leave there or not. It's- All right, cross, please.
Inquire,
Yes, ma'am.
thank you.
Mhm.
Good afternoon.
Open
Officer Rose, you are not the primary officer in this case, correct? I'm sorry?
Officer.
Harold, I'm sorry, I'm mispronouncing that, right? Sorry. Officer Harold, you are not the primary officer in this case, correct?
Correct.
Now, what you are called in this investigation is a backup officer. And you're called a backup officer because it is your job to back up the lead officer. Now, in this case, the lead officer was Officer Moses.
Yes.
And Officer Moses was actually being trained by Officer Roll.
Correct.
And Officer Roll is what is called a field training officer for Officer Moses.
Yes, ma'am.
And you guys sometimes use the acronym of FTO for the field training.
Correct. Yes, ma'am.
You testified on direct examination that when you first noticed this vehicle, it was because of Officer Roll approaching it with his flashlight, correct? Right, so it was Officer Roll that noted the individual in the back of the car first.
Yes, ma'am.
Now, when you first saw Mr. Davis, he appeared to be sleeping, correct? Objection, back on evidence.
Sustained. Come sidebar. All right, counsel, you may proceed.
Thank you, Your Honor.
Mhm.
Officer, when you approached the car, you were able to get a look at Mr. Davis, correct?
Not a clear view.
Not a clear view,
No, Officer Rowe was in front of me.
but you were able to see him, right?
Like I said, it wasn't a clear view, once Officer Rowe opened the door. Mind you, all of this stuff happened within seconds, you know? So Officer Rowe had the best view and the angulation of my camera, because you see, as I have a clip, I was kind of standing on the side, and I didn't get a clear view. The only thing that I was seeing was somewhat of a leg, and then Officer Rowe passing me by.
Okay, and did it appear to you from the angle that you were looking at that this individual was laying down in the back seat?
Yes, ma'am.
From your observations, what did it appear that this individual was doing laying in the back seat?
Like I said, only observation that I knew that if somebody possibly in the back laying down, but what he was doing, I don't know.
You were able to notice if the individual's eyes were open or closed? Yeah.
Do you not, could you see that?
No, I couldn't see his face. The only thing I seen was pretty much like a leg and like his shoes, but I didn't see his eyes or even his arms or facial area.
Officer Roll was the one that opened the door to the vehicle, correct?
Yes, ma'am.
And when Officer Roll opened the door, the individual that was inside didn't sit up right away, correct?
I wouldn't know. I didn't see if he actually set up or not. Because, I'm sorry, what?
Like, reviewing your body worn cameras to what you saw that's on your body worn camera refresh your recollection?
Yes.
For the record, I'm going to play from the time starting at 3:52:39.
Sure.
And I have now 3:52:55. Did viewing that portion of your body worn camera refresh your recollection as to what you saw Mr. Davis doing in the backseat of the vehicle?
Yes, ma'am. It refreshed my memory. Like I said before, all this happened in real time. Officer Rowe, once he opened the door, I was like basically at first where the officer is right there. And right as he opened the door, he grabbed the firearm. Like I said, the way the angulation of my camera was placed, it's placed at an angle where it had a better view than I did. As soon as he actually grabbed the firearm, I was actually told me to go secure the weapon, and that's when I went to the person's run up to check on it.
Okay, I'm gonna go to be playing through this portion for.
Okay.
As you were making the firearm safe, are you able to hear what the other officers are saying?
Directly, no, it was a lot of chatter that was going on. Once I got on the radio and I saw that, I was paying attention to what the actual Dade County dispatcher was actually doing.
So it's fair to say that you never saw the firearm inside of the vehicle.
Correct.
Fair to say that you never saw the firearm location and how it was related to Mr. Davis, correct?
Correct.
Okay. So you never also saw when or how the firearm was recovered?
I seen the recovery when Officer Rowe opened the door. The only thing that he reached in, grabbed the firearm, and that's when they put it on the trunk. But I didn't actually see the exact firearm.
Who wants to go further?
Sure.
From your interactions with Mr. Davis, do you believe that he appeared groggy in any way? Objection, motion, sidebar conference.
Counsel, sustained.
Mr. Harold, while you're making this firearm safe, I saw that you placed gloves on your hands, correct?
Yes, ma'am.
All right, and that was for the protection of both yourself and of the evidence, correct?
The reason why gloves was placed on my hand, especially, it's habitual for me. I don't know when we go and see who, what, when, what I have to touch. Preservation for myself, bodily contacts, and things like that. So it's habitual.
So it's what?
It's habitual for me to place gloves on.
Okay, and so it's part of your procedure every time you're handling evidence, both you said for your safety and for the preservation of the evidence, you always put on gloves, right?
So, for the reason I place gloves on, every officer is different. I do it because we come in contact with different people. And I mean, like bodily fluids, I'm big on hygiene. I don't want to have somebody gloves are open and stuff. You get what I'm saying? So that's why I do it. But say for, I didn't know that this was going to happen, you know, but I just made it habitual. Every time I'm on a call, I'm placing gloves on.
Is part of the reason why you put on the gloves to preserve the evidence?
No, no, ma'am.
So your gloves has nothing to do with preserving the evidence?
Correct. Yes, ma'am.
Okay. Now, you have the ability to test evidence if you so wish, correct?
Can you put that on?
Yeah, I'll explain. You're able to test a piece of evidence for fingerprints if you so wish.
I will do that. When it comes down to fingerprint, I know like we have our crime scene technicians. They're the one who will process the scene and come take like fingerprints and what's not.
Right, fair enough. You're not the one that physically collects the prints from the firearm, but you have the ability to request for somebody else to do that.
Correct. Yes.
Okay. And you also have the ability to request for somebody else to test evidence for DNA.
Correct. Yes.
Okay, so I want to talk about that ability. The procedure that you have to follow in order to make that request is to fill out what's called a lab request form, correct?
Yes. Analysis form. Yes.
What is
A lab analysis form.
a lab analysis form? And when you fill out that form, you indicate what the piece of evidence is, correct? Is that a yes?
Yes.
And what you want for the lab to do with it.
Correct. Yes.
Assuming that you would want to have it tested for DNA, all you would have to do is check the box for DNA.
Yes, ma'am.
And then you would submit that form to the lab,
Yes, ma'am.
and individuals that are trained to search for DNA and fingerprints would examine the piece of evidence, in this case, a firearm, at your request.
Correct. Yes, ma'am.
Okay. Now, you testified that this firearm was loaded,
Yes, ma'am.
meaning someone physically put the bullets in the magazine, correct?
Yes, ma'am.
And the magazine into the firearm,
Correct.
meaning that at some point, someone would have had to have touched the bullets. Objection calls for speculation, lack of knowledge.
Sustained.
In order to put the magazine into a gun, someone has to physically do that, correct?
Yes, ma'am.
And in order to put the bullets into the magazine, someone has to physically do that.
Yes, ma'am.
Okay. At some point, Mr. Davis gets a pat down of his person, correct?
Yes, ma'am.
Now, there's no firearm in his actual person, correct? He's not holding a firearm in his hand?
Oh, no, not at the moment.
There's no, I apologize, there's no firearm tucked into his waistband?
No,
There's no firearm in his back pocket?
no,
You don't see any bullets anywhere on his physical person?
no, ma'am.
And you don't see any magazine on his physical person?
Correct.
One moment. Officer, you did not do any investigation as to whether or not there were any surveillance footages that captured who came in and out of the car.
I didn't conduct that, no, any surveillance was received on my body like that.
Okay. And to your knowledge, let me ask you first, you did not submit a lab analysis form in this case.
No, not at all.
Okay, to your knowledge, one was not submitted.
No, the only thing that was completed was actually property receipts and firearms.
No further questions?
Any redirect?
Yes, Your Honor. Let's go into the gloves.
Yes,
You testified you put on gloves for personal safety.
yes, ma'am.
This happened October 16, 2020,
Yes, ma'am.
middle of a pandemic. Objection needing you.
Sorry, over.
Were we in the middle of a pandemic then?
Yes, ma'am.
Would it be safe to say that you were concerned about surfaces that you were touching?
Yes, ma'am.
Officer, why did you personally, I don't want you speculating as to what any other officer thought. Why didn't you request for a DNA sample swab off the weapon?
Well, first and foremost, this depends on the nature of the actual crime itself. Like I wasn't the lead officer, but it didn't fit the criteria, based upon what occurred that night. Now, if it was a different scenario, then it would have been me to actually request a lab analysis form. And if it, besides that, also too, like I said before, the crime scene technician will come out. And for example, if the gun had some type of bodily fluid, blood, anything on it, we would have preserved it, left it on scene, and then we will go from whoever the lab tech. But I won't touch it, without actually mess up the scene.
As you saw the gun, did you see anything on its surface, fluid, anything like that?
No, not at all. It was in clothes and all this.
Why did you not submit it for fingerprints? You personally?
Not gonna lie to you, I don't have a reason why, well, I didn't have a reason at that moment to submit it for fingerprints.
Did you care who had touched that gun?
No, I didn't.
Okay. Where did Officer Rule, based on what we saw, pull the gun out of?
The gun was up under his left leg.
Did Officer Rule pull the gun out of the car?
Yes, ma'am.
Out of the backseat of the car?
Yes, ma'am.
Where was the defendant laying down?
He was laying down in the backseat of the car.
Who else was in the car with the defendant?
So,
There was nobody else inside the car.
no,
One second.
All right, very well. Thank you, sir. You are excused. Do you want to go ahead and return the evidence, though, to the clerk?
We actually need to address.
Oh.
He might need to address.
Come on over here. Thank you. Thank you, sir. You are excused. Thank you again. This is time for parties. Is it time for me to read the stipulation?
That's correct, Your Honor. At this time, the state is not calling any more living and breathing witnesses. We ask that you continue.
All right, very well. Ladies and gentlemen, as will be explained to you and is explained to you, when the parties agree that certain facts are true, that is called the stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that Terrence Davis, the defendant, is a convicted felon, and that the convicted felon status element of the crime charged in this case has been established and proven beyond every reasonable doubt. State?
Your Honor, at this time, with the reading of that stipulation, the state rests.
All right, ladies and gentlemen, if you give us a few moments, I'm going to ask you please to leave your notepads at your seats. I know we're getting at lunchtime a little bit late. I'm going to get you off to lunch in a minute. Give us about 5 minutes. I'm going to ask you to step outside with Robert. We'll have you right back in. Thank you.
All right, with your
And please remember, do not discuss this case. We're gonna go back on the record. Now, Mr. Davis, I'm ready to have a conversation with you, okay? Have you had time now to speak with your lawyers about whether or not you wish to testify? Okay. And have you made a decision about whether you wish to testify? And what is that decision, sir? You do not wish to testify. Has anyone forced you to say that? This is your decision. It's not your lawyer's decision. Okay? And you absolutely have the right to testify. What the state could ask you is whether or not you have any prior felony convictions, which the jury's already been told that. They could not go into any specifics at all about anything in your history. Do you understand that? Okay. So I wanted to make sure you knew that if you did testify, the jury already knows probably the most dangerous part of testifying if you're a defendant. Okay. Is it still your desire, though, not to testify? Okay. All right. Oh, Yasser said Yasser couldn't hear you. Okay. You're not going to testify. Okay. Okay. All right. So the other thing is I want to chat about this. Okay. Because I'm just going to put my observations. I know you don't appear to be particularly happy right now. And you know, I don't want anyone, including yourself, to feel uncomfortable or angry. But I have to maintain very calm court. And, you know, I asked my bailiff to ask liaison to come up. I don't want them in the courtroom. I'm going to tell you that. I don't want it. I don't like it. Let me explain to you why I asked them to come up, though. Okay? It's because it's very important that there are no issues, that everyone stays calm. But I saw your reaction. You're a little bit agitated. And I understand that you could feel frustrated, but I have to kind of balance everything out. So I do not want, when I'm just having a conversation with Mr. Davis and with everyone, actually. I do not want any concerns or issues. And I don't think it's beneficial, frankly, to have, you know, show of police in the courtroom. I don't want to do any of that. So can we feel comfortable? Okay. I know you're not happy, and I get it. Okay. This is not a great, you know, it's tough. You know, we're in a trial. It all depends on how the jury evaluates the witnesses and the evidence. So are we okay, Mr. Davis? And again, I don't have any dog in this fight, sir. No one else does here. I just want everything to be very, very comfortable. Now, at the time when a verdict is announced, they always come in anyway, you know, okay? So, but I don't want them to have to sit in here at all. Okay? So that's why I asked the officer to come up, is because I wanted to have this conversation with you, and we can be honest we are being honest with each other. Okay? Because I also think that oftentimes a jury, you know, they're watching everything, right? And I just don't see that a jury would find it beneficial at all to whoever's accused of any crime to have extra officers in here. I think it doesn't help. So I don't want to do that, okay? So I don't need to do that. Okay, that's fine. All right, so you're gonna make your second JOA, but before you do that, let me just send the jurors to lunch. Then they're gonna come back from lunch at 2:15. Okay, when they come back from lunch, you're gonna rest in front of them after lunch, and then we will start closing arguments. Okay, I gave you the package of jury instructions. I gave you the verdict form. I think they're in pretty good shape, but you need to go through them and see if there's anything that's amiss. And we have our charge conference. Okay? All right, let's bring the jury in. Thank you so much. Appreciate it. I'll see you later sometime.
You ready, Ron?
Yeah, let's bring the jury in. Just let me give you this. See, done with deposition. Thanks. All right, very well, thank you. You can all have a seat. Thank you. Ladies and gentlemen, thanks for your patience. Thanks. All right, very well. Okay, ladies and gentlemen, brought you out to bring you back in. For me to tell you now, it's time to go to lunch. Okay? Please don't discuss this case with each other or with anyone else. I'm glad Robert got you some coffee because it gets so cold in here. We're gonna have you back at 2, let's make it 2:30. When you come back, the parties will be presenting their closing arguments. So you should, then we'll get the case once you hear the closing arguments. And I'll instruct you on the law, and then you will be given the case. Don't do any research. Don't try to gather information. That's not evidence. Evidence is what you got in the courtroom. And that's all you can rely on in ultimately reaching the verdict. Okay? If you see us, we're not going to talk to you. Everyone here is reminded, please, no contact or communication with the jurors. You see them, just walk away and don't speak in their presence. If you see any of the lawyers, any of the parties around, don't listen in on the conversations. We'll have you back then, as I said, at 2:30. You can leave the courthouse if you wish to get lunch or have lunch in. I think it's still raining out. I don't know. In any event, have a pleasant lunch and see you back then. Robert will let you know where to meet him.
All right, George.
Thank you. Okay, so we'll take our lunch break now. See you back. Make it if you would all be back here at 2:25, because I want to address the jury instructions before closing. I do not instruct them though before closing. I instruct after closing. Some people do differently, but I instruct after the closing arguments. How long do you anticipate state your closing argument will be?
Your Honor, just inquiring, are you going to give us a time period and split it up?
I'm going to hear what you have to say first, and then I'm going to figure out what I think is reasonable.
I would ask for, probably not, it's not going to be any longer than half an hour. I'm just
Oh.
going to say.
Okay, I thought you were going to say something like 2 hours, and I was going to say, no, that's not going to happen.
I would ask for 45 minutes and then split,
Ladies and gentlemen, we're back on the record. We're going to bring the jury in for closing arguments. Okay, all the parties are present? Very good, thank you. Jury will be coming in for closing argument.
All right, for the jurors.
Please be seated, thank you. Welcome back, ladies and gentlemen. Hope you had a pleasant lunch. We are now at the point where the parties have rested, both state and defense. The attorneys are now going to present their final arguments. Please remember what the lawyers say is not evidence. However, do listen carefully to their arguments. They are intended to aid you in understanding this case. Each side will have equal time, but the state is entitled to divide their time between an opening argument and a rebuttal argument after the opponent has spoken. For the state? Mhm.
And I'm going to be showing your honor the demonstrative aid we're going to be using for our police. Ladies and gentlemen, I told you earlier today that we were going to prove the true elements of this crime before we even got. I told you what we were going to show you, what you were going to hear, and we had it here. We showed it. You saw the video, you heard the officer's testimony. Some of you touched the evidence, touched the gun, saw how it felt. Now, this here, it's not the prettiest, but it's a document. And we're going to go through the jury instructions that you get later on. These are not it. These are another version of it. But these are the elements of the crime. But the state proves beyond a reasonable doubt. Before you can find the defendant guilty of felon possessing a weapon, the state must prove the following two elements beyond a reasonable doubt. Element number one, defendant had been convicted of a felony. We didn't have to prove that. That was stipulated to. When there's a stipulation, that's proven beyond a reasonable doubt. Not only is that, after the conviction, defendant knowingly had in his shared custody possession of the drug. No, let's talk about that. This is how the state proved that he knowingly had that firearm in his care, custody, possession, and control. It was under him. It wasn't by him. It wasn't close to him. It wasn't around him. It was under him. You heard the officer say it was within his reach. He could have grabbed it if he wanted to. It's a hard piece of metal. Wasn't soft, wasn't a piece of clothing. It wasn't something that could have been mistaken for a blanket. It was a hard piece of metal that one would certainly feel if you're laying on top of it. There was nobody else in the car. No one. The defendant was alone. He was in the back seat. Nobody else, not even in the front seat. Except for when the officer reached in to grab the firearm, nobody else was even near it. Just the defendant who was laying on top of it. The gun was on the seat, under the defendant who was laying on that seat. It wasn't put away. It wasn't in a casing. It wasn't in the glove compartment. It wasn't in the center console. It wasn't under a seat. It wasn't in the back of the back seat. It was on the seat that the defendant was laying on. It was under him. You also heard Officer will testify in response to whether that was his weapon or not. He responded, yeah. We have that. We have the statement. Saying that it's not. Lastly, we have his behavior. We heard evidence that he was unruly, offensive, belligerent, upset. That is, all that evidence leads to the reasonable conclusion that this is someone who got caught doing something he wasn't supposed to be doing, and now is upset about it. Let's move on to the next element, and I am now reading from the jury instructions that you guys are going to get. That's knowing care, custody, or control. Again, care and custody mean immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. We submit to you, ladies and gentlemen, that it was under his care, custody, and control. Again, it was under him. May I have exhibit 4, please? This wasn't there. It was here. It was here. Right here. Within reach, touching his body, where he could feel. There wasn't anyone there. Control. Who else had control over that? Nobody else was there. The defendant possessed a firearm or ammunition. The state must prove beyond a reasonable doubt that he knew of the existence of the firearm and exercised control over it. We already went over knowing. We already went why he must have known that that was there. It was under him, it was touching him, there was nobody else there, it wasn't tucked away, it was right there laying on the seat. Control can be exercised over a firearm, whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. This is telling you mere proximity is not enough in the absence of additional evidence. Not just that mere proximity is not enough. In any case, this was not nearly, approximately close to his body. It was on him. This is mere proximity. This is not. Mere proximity could be, he was walking in the park, he sat on a bench, there was a gun under him. That's mere proximity. This is not the case today. That's not what happened here. Possession of a firearm, control can be established by proof that the defendant had direct personal power to control the firearm or the present ability to direct its control by another. For the officers, it was there, he could have grabbed it, he could have rolled over it, he could have pushed it, it was under his control, he could have done whatever he wanted with the weapon. Lastly, we need to prove that firearm. For the officer, he's trained around weapons, he recognizes a firearm, he knows what kind of firearm it is, he knows it's a Glock 19 Generation 4. He pulled a bullet out of it. He could have magically pulled a bullet out of it. You all saw it. Some of you touched it and held it. The officer testified. This is not a toy. This is not an antique. If he, as they found it, if he would have pulled the trigger, a bullet could have come out of it. If this gun was not made safe and I would put a bullet, it can come out of it. It's a gun. Today, the state submits that we have proved each and every one of these elements beyond our reasonable doubt. Based on all the evidence that you heard today, what you saw, what you felt, some of you, the only logical conclusion that can be reached is that this defendant, who has been convicted of a felony before, was in possession of a firearm on October 16, 2020. I'm going to come for your honor. I'll repeat myself. We have proven every element of this crime today beyond a reasonable doubt. We therefore ask that you find the defendant guilty of this crime.
Thank you, counsel. Closing for the defense.
Yes, sir, if I can set up the courtroom.
I'm sorry.
If I can set up the courtroom.
Of course.
Thank you. And your honor. Okay, go sidewalk. I saw it not. Oh, okay. My fault. Permission to proceed, Your Honor?
Please.
Thank you. Members of the jury, we can all agree on one thing here today. And that thing that we can all agree on is the fact that Mr. Davis has been in fact convicted of a felony. I told you as much during jury selection that that was something that we as defense were stipulating. We were agreeing
However, members of the jury, what we cannot agree with, what we will not stipulate to, and what the state has failed to prove to you beyond and to the exclusion of every single reasonable doubt, is that Mr. Davis possessed any firearm knowingly and with the ability to exercise control over it. Now, I want to discuss specific parts of the evidence of why the state did not meet their burden in their case here today. But it's important for you to know that the reason why we cannot agree with it is because it's simply not true. Because Mr. Davis is innocent of the charges that he is accused of here today. Members of the jury, what happened in this case is plain and simple. On October 16th of 2020, the police responded to this motel for some unrelated reason to Mr. Davis. They were investigating something else. This vehicle that was in the parking lot was in the on position, the ignition was on, and it caught the officer's attention. So they diverted their attention to that vehicle for safety, to make sure that the person that was in the car was okay. And Officer Roll told you that what he did is he brought his flashlight up to the car and looked through the window, and he saw a person and a gun. And he proceeded to open the door of the car, remove the gun, and give it to his partner to make it safe. Let's talk about that. That's what happened in this case. We're not disputing the fact that the gun was in fact found next to Mr. Davis. We're disputing whether Mr. Davis knew of the existence of that gun, ever even touched that gun. Members of the jury, no evidence was presented to you here today regarding how or when Mr. Davis entered that vehicle. Mr. Brody and I asked questions of these two officers regarding the surveillance of the motel. You heard that one officer didn't look for it because they initially got there for an unrelated incident, and the other officer said he believed, without anything to back it up, that it wouldn't show anything in the cameras. But the bottom line is, there were surveillance cameras, and no one bothered to go in to look what they showed. If nothing more, you would see how and when Mr. Davis entered that vehicle. And you'll find out why that is important. You heard the state attorney come up here and tell you, well, what the defense is showing you is not mere proximity. Had someone walked up to a park bench and just sat down and the gun was just there, that would be mere proximity. But we can't make the same connection in this case, members of the jury, because we don't know if when Mr. Davis got into the car, the gun was already there or not. The state did not present to you any evidence regarding that fact. There is no one here that told you that they went and traced the surveillance footage to see how and when he got in. So let's talk about what Mr. Davis looked like. Mr. Davis was wearing long white pants, and he was without a shirt. You heard the officers tell you that there was no holster, nothing to carry this gun on, nothing. So if the state would be saying that here this man is with a gun either tucked into his waistband, tucked into his back pocket, or just carrying it bare in his hand, the surveillance video would have shown you that. But the only evidence that we have here is how it was recovered and not how it got in. So let's talk about this recovery. We do not lose as jurors our common sensibility to process the evidence. So I want you to think critically of all of the facts. Let's take them one at a time. The first critical fact that we have is that Mr. Davis is seemingly doing something very dangerous, members of the jury, You heard the officers testify that in the chamber of the gun, there was a bullet, a live round. Can you imagine knowing that you are laying down on top of a gun?
Overruled.
Laying down on top of a gun that if you move the wrong way can kill you? But they want you to assume that he knew that, he was well aware of that, and he didn't care, he just laid on it. Now, I want to be clear, the prosecutor, Ms. Garcia, she was explaining to you that the gun was on him, and she was positioning her hand in her upper waist. That's not what the testimony was here today. The officers told you that they recovered this firearm from underneath his leg. And I want to show you something in the surveillance video. While my co-counsel sets up the video so we can rewatch it, I'm going to tell you what I want you to pay attention to. When the officer opens the door, Mr. Davis doesn't sit up right away. Get scared. When the officer reaches in and grabs the gun, Mr. Davis doesn't sit up. In fact, members of the jury, I want you to watch what happens. They say it's under his leg, right? But you don't see Officer Roll lifting his leg to grab the gun. You see something else. You see Mr. Davis putting his leg up as he is laying on his back. Okay, common sense, let's think about that. I'm a convicted felon. I'm laying in the backseat of a car. I brought a gun in here with me that's laying on me. The cop just opens up the door and I'm gonna expose that gun. Just let him see it right there under my leg and let him know, hey, I'm committing a crime. He wasn't hiding that gun, he did the complete opposite. And I will show that to you, members of the jury. I want you to focus on these things that just don't make sense. If you're aware of an item and you're aware that you're not supposed to have it, why on earth would you expose it in that way to make it so easy for the police to see? Why would you do that? You would do that if you did not realize what they were looking for, what they had seen, or what they were about to grab. And for the record, if you want to view this afterward, you will be able to go back to these numbers. So I'm going to, for anyone taking notes, I'm going to tell you where the position for this is. The time is 3:53 with 43 seconds. Sorry, 52 seconds. So when we look here that he first approaches the car, both of Mr. Davis' legs are curled up next to his body. And I've only said you can't see it because there's angles of the body worn camera that you can see, but I can't.
Overruled. Again, ladies and gentlemen, it is for you to view the evidence and make your determinations. Counsels, attorneys are permitted to make argument based on reasonable inferences from the evidence presented. Go ahead, counsel.
And as he's sitting here, he has his legs here. The officer told you, I was able to see the gun. I know that you can't see it now on the body or the camera, but I was able to see it there live in person. If you see this part, members of the jury, at 3:52:45, Mr. Davis raises his leg up on top of his right leg. Mind you, the police haven't reached in for the firearm yet. This is what I am talking to you about. Now, members of the jury, now Officer Roll reaches in and grabs that gun. Perfectly accessible to him. He doesn't reach underneath his buttocks. He doesn't have to reposition his leg. He's able to have ready access. And why? Because Mr. Davis unknowingly moved his leg out of the way to expose something that was there. Now, the leg up is one thing. I want to talk about the movement. Officer Roll told you that, yes, the engine on caught his attention, but also that from the front windshield, he was able to see some movement in the car. Now, the movement, he told you, wasn't someone sitting up. So the movement was someone still laying down that he was able to see it. Maybe something like this. It wasn't specific, but movement while someone is laying down. Now, if Mr. Davis was fully knowledge of this gun, all right, and he was in fact moving, he's aware that there are cops right behind his vehicle, parked right there. And if he's moving and he's alert, he would be able to grab that gun and put it, I don't know, underneath the passenger seat, put it underneath the driver's seat, put it in the center console, put it in the glove compartment. You're alert. You're wide awake. You know what's happening. You know when you possess the gun, so hide it. Don't expose it. And none of that happens. The gun isn't moved from location. The gun isn't hidden from view. The gun isn't trying to be concealed with his body to make sure that nobody else sees it. What does that movement tell you? Nothing. Because if it was conscious, knowing movement, he would have hidden that gun somewhere to make sure that those officers didn't see him with something that he knows he's not supposed to have. It is true that this gun was in fact next to Mr. Davis. But because he didn't know that it was there, he could not exercise control over that firearm. So, see, from Officer Roll's perspective, it was easy. Open and shut case. I open the door, there's a person there, I retrieve the gun, I run him, he's a convicted felon, he's not supposed to have a gun, case closed. Now, there was a problem with that. You will hear that there is a jury instruction that reads as follows. Mere proximity to a firearm does not establish that the person intentionally exercised control over it in the absence of additional evidence. So, what do we need? Additional evidence. Because all you have there is Mr. Davis with mere proximity to a gun. That's it. So, how do they go about getting this additional evidence? Simple. A statement. If we can get a statement from Mr. Davis saying, I knew the gun was there, the gun is mine, I've touched the gun, I've seen the gun, I brought the gun in the car, that's some additional evidence. Maybe not great, but it's something additional. So that's exactly what he does. If you're so sure that this man sitting in that car knew about that gun, why is the first thing when you come out of the car you ask him, hey, is that gun yours? It's next to him, right? It's there. He's gotta know about it. He should know, could have known, would have known. So why are you asking him if it's his? If you're so sure he knew, just based on the proximity, why ask? So, Officer Roll tells you that Mr. Davis responds, yeah. A mumbled statement that you can barely hear. Now, he tells you, here are all the things wrong with this statement, this yeah. One, you barely hear any response from the body worn camera when that statement is made. If any. Two, interesting, the camera that would have probably captured that statement the best would have been Officer Roll's body worn camera, right? He's the one that heard it. You know, Officer Harrell took the stand too, and he didn't mention anything about any state. And he was right there. He was standing right there, and Harrell didn't say a single thing about hearing Mr. Davis confess to owning any gun. It's just a word of this one officer, Officer Roll. So Officer Roll comes in, and he says, yeah, that's what he answered my question. My body worn camera, I turned it on, I heard the chime, I thought it was on. But I realized later as my investigation went on that it wasn't on, and then I made sure to turn it on. Mr. Brody asked him some questions about when he activated his body worn camera, and he gave two different responses. The first one was, I realized while I was there, and that's when I turned it on. And the second one was, I realized that my camera had not captured the whole incident afterward, after reviewing my notes. So which one is it? Because your camera can potentially contain a critical piece of evidence, that would show Mr. Davis admitting that the gun was his. Members of the jury, let's talk about the observation and behaviors of Mr. Davis. Mr. Davis is laying down on his back. You heard Mr. Brody ask an officer, well, hey, there was a hand that came into the vehicle before Mr. Davis stood up. And he said, I really can't see it from here, so Mr. Brody had to get up, and he walked over and he looked closer. Mr. Brody asked him if someone had to either tap him or tap the chair. And Officer Roll said, I actually do not remember. And Mr. Brody said, I will play for you the portion. And he did. And in the portion we hear, and again, during that same segment, you hear, yo.
Objection, Judge, that's not evidence.
Oh,
Objection, Judge, Marisa, sign off.
no, oh, you can reserve. You want.
We hear. And again, yo, get up. That's 3:53:05 to 3:53 with 20 seconds. From Officer Moses's body worn camera. Yo, get up. He didn't hear the officers open the door. He didn't feel the officers removing the firearm. He didn't feel when the firearm was being given to somebody else or here. The police officer is happy on the chair, on him. Yo, get up. None. When Mr. Davis finally sits up and starts acknowledging the bombardment of questions that are coming from the officers, he gets asked a question, right? The famous statement, is the gun yours? Officer Roll seemed to think that ownership of the gun was an important statement. But when Officer Harrell took the stand, the state questioned him, the defense questioned him, and then the state got an opportunity to do what's called a redirect and ask him additional questions. And there were 3 specific questions that the state asked of Officer Harrell. The first one, did you care who owns the car? No. The second one, did you care who owns the gun? No. The third one, did you care who touched the gun? No. So if who owns it and who touched it doesn't matter, then what does? It should matter to you, members of the jury. You are the ones making the determination in this case of exactly what happened. And you deserve evidence of someone that cared that you would have to take more than just someone's word for what happened. So, he doesn't care who touched the gun. Why is that important? Why should he have cared and why should you care? Well, members of the jury, if in fact Mr. Davis had touched that gun, had touched the bullets to put into the magazine, had touched the magazine to put into the gun, and at some point carried and put it in his pocket, you heard no evidence of Mr. Davis carrying gloves around him. That would have left behind a critical piece of physical evidence. Now, why do I stress that physical evidence? Because physical evidence does not lie. Physical evidence tells you exactly who touched an item. Now, don't let the state come up here and tell you that you didn't need DNA, like Officer Roll told you. Or tell you like Officer Harrell. I don't know why. I don't know why he didn't take the DNA. Because you better believe that there was a fingerprint that matched Mr. Davis on that gun. They would have rolled out a red carpet and brought fingerprint analyst after fingerprint analyst to show you that this man touched that gun. Don't let them tell you otherwise. That would have told you, well, at some point, it was in his hand, not just on his leg near his person. That would have told you definitively he touched that gun. I was talking to Officer Harrell about his gloves. Because at that point, you would think, yes, for personal reasons, especially during a pandemic, we want to wear gloves when we're handling it. But you get an unintended result that you get to preserve whatever evidence is on there. Now, he said that he personally just does it as habit, and that he personally was doing it for his safety. But the fact is that the gun was there preserved with him. He did what he had to do and he wore the gloves, and there it was preserved. So, yes, Officer Roll doesn't know how to take frames, doesn't know how to dust for them, put the tape that goes, move them, put them on fingerprint card, none of this.
Ladies and gentlemen, again, I remind you that the lawyers, what they say is not evidence. You decide what the evidence is based upon your recollection of what's been presented to you. This is final argument, and they're permitted to argue what they believe are reasonable inferences that can be drawn from the evidence, but you decide what the evidence is. Thank you.
You're sure. He said it's not his job. That's not what he does. But guess what he did tell you also? There are people in his police department whose job it is to run these types of analysis. He, either Officer Roll or Officer Harrell, all they would have had to do is grab this form. And I tried to describe it for you as best as I could. Just a form, one sheet, At the top, you write the case information, and there's some boxes that you check off at the top as well. You want DNA? You want fingerprints? What do you want the lab to do? You submit that form with your property receipt, and it also goes. A box. A check mark. And it wasn't done. How simple would it have been for Officer Harrell or Officer Roll to take it upon themselves to say, this needs to be done. The jury doesn't have to speculate on a video or determine if we're telling them the truth. There's going to be physical evidence that will tell them what happened. Same goes for DNA. If they decided to check a box, members of the jury, you would be able to determine if any of Mr. Davis' DNA was on that gun. And you did not hear that evidence here today because nor Officer Harrell nor Officer Roll decided to bother with the very complicated task that was to check a box. Because in Officer Harrell's words, I don't know why we did it. Members of the jury, while Officer Roll was testifying on this direct, he said that it was a little bit chaotic at the scene. There were people talking, there were people arguing. And all of that's when he said that the statement occurred. When Mr. Brody went to ask him about, so you said there was people there talking on scene, he was like, I don't remember. Mr. Brody had asked him, you don't remember what you just said on direct examination? But the reason why that's important is because if you knew that it was loud, that people were talking, you might think, well, maybe the statement's not captured as well as it should be. After all, we have its own body where camera was working. So what could he have done to make sure that that statement was memorialized in some other way to make sure that you would be able to see it? Well, we asked him about his office. You have paper, you have pen. He's clearly willing to speak to you and answer your questions. Because he did. Give him the paper, give him the pen, and have him write it down. And say, hey, Mr. Davis, did you just say that the gun was yours? Can you repeat that one more time for me? No repetition, no writing it down, no nothing. Take my word, that's what I heard, that's what I saw, that's all you need. The whole time, members of the jury, that these officers are on scene, there's no further investigation that's done. Because clearly they weren't filling out an analysis form. And Officer Roll and Officer World told them they're backup to another officer. So they're not the ones that authored the report. So you know they're not doing that. The only thing that you know that happened during that long amount of time that we were watching that video is that they were running things. They were running people's background checks. They were running the firearms to see if they had been reported stolen. That was it. That was the only investigation that these officers managed to do during that short period of time. Objection, tax on no.
Sustained. Can I see the lawyers for a moment, please? Thank you. Council, sorry for the interruption. The last objection was sustained, ladies and gentlemen. Please disregard the last statements by council. They were improper and not supported by the evidence. See.
Thank you. Members of the jury, as the fact finders in this case, it is your responsibility and your responsibility alone to determine what evidence you find credible. You're allowed to believe all of the evidence, none of the evidence, or parts of the evidence, as you deem appropriate. You're going to get an instruction, it's called weighing the evidence. And that will give you several questions that you can ask yourself. Was the witness honest and straightforward in answering the attorney's questions? Did the witness seem to have an opportunity to view the things that they testified on? And you will be able to make the determination as to what you wish to believe in this case. But with that, members of the jury, comes also the jury instruction of reasonable doubt. And the law says that you can find reasonable doubt in three phases. You can find it in the evidence itself, in the lack of evidence, or in conflicts in the evidence. Now, the biggest reasonable doubt that you have here, members of the jury, is that there is no evidence that Mr. Davis knew or controlled the firearm. The jury instruction tells you that knowingly means with actual knowledge and the understanding of the facts or the truth. Knowingly means an act done voluntarily and intentionally, and not because of mistake or accident or other innocent reasons. For control, it is true that control can be exercised whether something is on a person or near a person or in a completely separate location. But mere proximity to the gun, just because it's next to you, is not sufficient in the absence of additional evidence. Control can be established by proof that Mr. Davis had direct personal power to control the firearm or ammunition. Members of the jury, whether he had knowledge or control, that fact is riddled with reasonable doubt. And you know, the beautiful thing about reasonable doubt is that you don't all have to have the same reasonable doubt. You can each have a different reasonable doubt. One reasonable doubt can be the fact that the police did not bother to submit the lab analysis form for fingerprints. Because if they had, they would have shown you that Mr. Davis never touched that gun. Another reasonable doubt could be the fact that not only did they not submit the lab form on that day, but here we are, several months later, and it was never submitted because you were not presented with any fingerprints, any physical evidence for prints at all. Another reasonable doubt would be the fact that not only did they not submit their lab analysis form for fingerprints, but they did not submit the lab analysis form for DNA, which can also tell you who touched or came into contact with the firearm. Another reasonable doubt can be the fact that these officers don't have a good reason why this wasn't done. They didn't tell you it was against policy or inability to do so. Simply the fact that they don't know why they didn't do it. And that lack of evidence, that lack of investigation can be your reasonable doubt. Another reasonable doubt can be the fact that no one bothered to check out the surveillance videos to see when or how Mr. Davis got into that car. He was holding a gun, or not holding a gun. No one even bothered to look, knowing that there's cameras there pointing to the parking lot at any point. Another reasonable doubt could be the fact that the importance of ownership by one officer is that it doesn't matter to him who owns the gun. And Officer Roll says that that was exactly what he asked him, if he was the owner of that gun. So to Officer Roll, it was important, but not important enough to make sure that the statement was repeated, spoken louder, written in any form. Another reasonable doubt could be that although Officer Roll told you that he was standing next to Mr. Davis when this statement was made, and that Officer Harrell was right there, Officer Harrell did not testify at any point to having heard Mr. Davis make any comments whatsoever about hearing a statement. The last reasonable doubt can be the fact that Mr. Davis exposes this gun to the police. He doesn't try to hide it under the driver's seat, passenger seat, glove compartment, center console. He doesn't try to hide it with his body, which shows that you're trying to hide something. He does the complete opposite, and he moves his leg out of the way for the officers to be able to have full access to it without having to move his body out of the way. Going to confirm.
Mhm.
I'm confident that now that you have heard all of the evidence in this case, you are going to reach the only just verdict in this case. The only verdict that we say speaks the truth. The only verdict that justice demands, that the evidence supports, but most importantly, that Mr. Davis deserves. And that's a verdict of not guilty. Thank you.
Thank you, counsel. State, rebuttal close. I don't know if you want to keep the item in. Mhm.
May you please report, Your Honor?
Yes, ma'am.
Defense counsel. Full counsel, this first statement. There are some things we can agree on. I agree on reading the comments. I do. That's the one big thing that the state board asks him to do, to go back to the jury room. I don't agree with defense counsel's comment about the how and the when. Because at the end of the day, ladies and gentlemen, you're gonna get a packet of the jury instructions. Mine have a message, made a fresh step. To prove the crime of possession of a firearm by convicted felon, the state must prove the following two elements beyond a reasonable doubt. The defendant, Karen Davis, had been convicted of a felony. After the conviction, the defendant, Karen Davis, knowingly owned or had in his care, custody, possession, or control a firearm or ammunition. I'm sorry, I'm missing the state has to prove when he became in possession of that firearm. I'm sorry. I I don't see that there. Because it's not there. That's not an element I have to prove. And it's not something you should consider because it's not going to be found in the jury instructions. We're going to go way back to the beginning. Okay? I'm not trying to sound condescending, but I'm going to harken back to when the judge talked to you on one here and said, you're not allowed to consider this. There are house rules. You have to follow the house rules because this is what makes it fair for everybody. You don't get to come up here and claim that I have to prove something that I don't. Who's going to make it? It's not in the instructions. No. We have to prove those two elements. Convicted felon, possession of a firearm, and didn't know it. Do I have to prove? May I please have exhibit 4, please? Thank you. I pulled out exhibit 4. Do I have to prove how many people touched this gun? How many people touched this gun? That's not relevant. Objection to the law. May I continue on? Just prove. I have to prove that one person touched this gun and was in possession of the gun. I have to prove one person, the defendant. For all I know, Mickey Mouse had this gun beforehand. I don't know. I don't want you thinking about that. Because that's not relevant. What's relevant is who possessed that gun on October 16, 2020. At that time, on the video that you saw, this is a very rare chance. You get to see this. It doesn't matter how many people came in and out of this car. Is it allegedly their car? The state has to prove not the when, not the where the defendant had this gun in his possession. We do have to prove, I shouldn't say that, that is a mistake. We do have to prove when and where. I'll tell you when and where. October 16, 2020, where? Miami-Dade County. This defendant, in the back of a running vehicle with his lights on, had this firearm in his possession. I really implore each of you to touch this, to feel it, and use your common sense. Defense counsel asks you to imagine. You don't have to imagine. You have it here with you. So let's get to that. Then, the state's gonna get up here and argue. They tell you the state's gonna get up here and argue. Of course I'm gonna get up here and argue. That's what I'm here for. But I'm gonna speak. You're gonna let the state speak for itself right here, right now. I'm gonna tell you this. When we talk about DNA and fingerprints, and we want to harp on that, and we want to say, they didn't bring it to you. Look at those officers. They just came in here, and it was just, we don't care. We just picked up a gun and decided, without any investigation whatsoever, to just blame it. Objection that agrees with the defense. That's not what happened here. No, you get to judge the credibility of these officers. You get to see what they did. That's not for anyone else to tell you. That's not even for me to tell you. Because you know what? It doesn't matter what I tell you, and it doesn't matter what they tell you. It matters what they told you, because that's evidence. This is evidence. And as for DNA and fingerprints, I'm gonna lie, that's evidence too. Straight up, that's evidence. But it's not evidence in this case. It can be evidence in another case, but that's not the evidence in this case. Yes, you can use the lack of evidence as reasonable doubt, but not in this case. Objection to statement of the law.
I'm gonna overrule that. Lack of evidence is a basis for reasonable doubt, as you will be instructed. That is the law. Go ahead.
But not in this case, because we brought you the evidence. You saw it for yourself. DNA and fingerprints are very nice to have in a whodunit type of case. Done it. We don't need to wonder who done it. Terrence Davis did it. And we know he did it because of how angry he was and belligerent he was afterwards. Would I love to have fingerprints and DNA in every single case? Yes. But ultimately, what defense counsel doesn't have, and what they didn't tell you, is that even if you swap it, even if you put the little dust cover on it, which she says Officer Wu didn't know how to do. Nobody asked him if he knew how to do it. That was incorrect. Nobody asked him that question. We asked him why he didn't do it, but nobody said, hey, you don't know how to do it, so you just didn't bother to do it. No. Nobody asked him that. Not every case needs that. Doesn't require it. And again, I'm gonna go back to the jury instruction. I'm gonna say, no, it doesn't have it in there. Your job is to follow the law. Defense is asking you to defend disbelief. They're asking you to force the doubt. They're asking you to imagine the doubt. It's a reasonable doubt. That's what it is. We talk about Officer Harold. Officer Harold. He didn't say nothing about escaping. Because no one ever asked him. Officer Harold's job on that scene was the gun. I asked Officer Wolf, what does everyone do on a police scene? He does this, the other person does this, the other person does this. Everybody's doing something. We talk about a big thing about the leg, the movement of the leg. Why would somebody do that? They're asking you to think why someone would do that. But at the end of the day, you're not a witness in this case. You can't imagine why somebody would do that. The facts are here. These are the facts. If we started to imagine everything in this world, we wouldn't stop. Why would we do that? Why? Let's think about why we did it. Why did we do it? Doesn't matter. That's not in the jury instructions. You don't have to find or answer the question of why somebody did what they did. That's not your duty. Think. No. I'm not telling you not to think ever. I'm just telling you that as your role as jurors, you have evidence. You have the evidence. The state brought it to you. That's what we brought you. I'm not bringing you possibilities. I'm not bringing you questions. That's not my job. I bring you evidence. And your job is to review the evidence critically. I agree with defense counsel on that one, critically, using your common sense. That is your role with jurors. And use that evidence to come to a conclusion. And in this case, ladies and gentlemen, the only conclusion, reasonable conclusion, using your common sense, using the evidence, rewatching the video, is that the defendant is guilty. He was mad as hell about it. He's guilty. We don't need to go into any further information about why and how he moved his leg. Maybe he moved it to show the police officers that, hey, I have a firearm, here it is. Maybe he was doing it for his own safety. I have no clue. We have millions of reasons. But that's not your job. Talking about surveillance footage and video camera, ladies and gentlemen, that's not before you. And I have no clue what that would have shown. Most likely, it would have shown what we already see. A vehicle running with the defendant in the back, exercising control, and the only one in that vehicle. And you know what? I don't want to speculate how that firearm worked out. Maybe aliens came down and dropped it from the sky, but that's not reasonable. And it's also not relevant. Because we're talking about the defendant being possession. And the first video went over, and you're going to read over again and again and again about the possession. That's all that matters. Now, I don't want to gloss over the statement. The defense brought that up. Yeah. He said it. There's no denying it. No one said he didn't say it. He said it. They're talking to you about then why did he write it down? Well, remember, if you saw that officer standing on the screen, berating that defendant to have him repeat it again and again and again and again and again and again and again, then you wouldn't like that officer very much, would you? What is he doing? You have your answer, man. Leave it alone. There's a lot more on that video footage that you don't see. So to get up here and say that these officers didn't do their job, that they didn't bother to do their job. No, they did their job. They confirmed me with a convicted felon. Using your eyes, their visuals, and everything they learned from the scene around them, which unfortunately I can't bring to you. I can't bring it. I want to, I can't. The house rules won't allow it. But I can tell you from their investigation.
I'm going to sustain as to the form of the argument. You can rephrase that, counsel.
I'll move on. To say these officers did nothing is wrong. Everything they did that night, unfortunately, I think. Objection on the statement of
Sorry. No? Okay. You can move along with that and continue. I'll move along there.
At the end of the day, pursuant to their investigation, they made the determination that the defendant, the convicted felon, and knowingly possessed that firearm. The state is now bringing the charges. We have shown you the evidence. I submit to you, ladies and gentlemen, use your common sense, use the evidence. Remember this officer. been being touched. Those officers were respectful. And did nothing to coerce anything out of this defendant that he wasn't willing to give. At the end of the day, I can tell you what the evidence is going to, what the evidence to lead you to. You have to make that judgment for yourself. But the state submits to you that based upon all of this, everything, including you see your common sense, it can't be left it out, can't take it out enough, they can't say it enough. The defendant is guilty beyond a reasonable doubt. A reasonable doubt. Thank you.
Thank you, counsel.
Oh, of course.
If you would all stay where you are, Ladies and gentlemen of the jury, you have heard all of the evidence in this case as well as the final arguments of the lawyers for each side. It is now my duty to instruct you on the rules of law that you must follow and apply to arrive at a verdict. You, as jurors, are the judges of the facts, but determining what actually happened in this case, that is, in reaching your decision as to the facts. It is your sworn duty to follow the law I am now going to define for you. You must follow all of my instructions as a whole. You have no right or authority to disregard or give special attention to any one instruction or to question the wisdom or correctness of any rule of law that I state to you. Accordingly, you must not substitute your own notion or opinion as to what the law is or should be. It is your duty to apply the law as I give it to you. And you will get a copy of the instructions to take back with you into the jury room, as well as a copy of the verdict form. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. Terrence Davis, the defendant in this case, has been accused of the crime of possession of a firearm by a convicted felon. To prove the crime of possession of a firearm by a convicted felon, the state must prove the following two elements beyond a reasonable doubt. One, the defendant, Terrence Davis, had been convicted of a felony. Two, after the conviction, Terrence Davis knowingly owned or had in his care, custody, possession, or control a firearm and or ammunition. Conviction means that a judgment has been entered in a criminal proceeding by a court pronouncing the accused guilty. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the actions of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, any machine gun. Ammunition means an object consisting of all of the following. A fixed metallic or non-metallic hull or casing containing a primer. B, one or more projectiles, one or more bullets or shot. C, gunpowder. Care and custody means immediate charge and control exercised by a person over the named object. The terms care, custody, and control may be used interchangeably. To prove Terrence Davis possessed a firearm and or ammunition, the state must prove beyond a reasonable doubt that he knew of the existence of the firearm and intentionally exercised control over it. Control can be exercised over a firearm and or ammunition, whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a firearm and or ammunition does not establish that the person intentionally exercised control over it in the absence of additional evidence. Control can be established by proof that Terrence Davis had direct personal power to control a firearm and or ammunition, or the present ability to direct its control by another. Possession of a firearm and or ammunition may be sole or joint, that is, two or more persons may possess it. Knowingly means with actual knowledge and understanding of the facts or the truth. Knowingly means an act done voluntarily and intentionally, and not because of mistake or accident or other innocent reason. As previously explained to you, when parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. In this case, the parties have stipulated that Terrence Davis is a convicted felon, and that the convicted felon status element of the crime charged in this case has been established and proven beyond every reasonable doubt. Members of the jury, also, you have viewed and listened to video recordings. The recordings have been muted to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recordings have been muted should not concern you in any way and must not impact the way you view and or listen to and consider this evidence. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. The state must prove that the crime was committed on October 16, 2020. It must be proved only to a reasonable certainty that the alleged crime was committed in Miami-Dade County. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony deserves more or less consideration than of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant has exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice.
Your Honor, we have extremely apologize for that.
Sure. All right, I apologize, ladies and gentlemen. Once in a while, there's a little bump I needed to address. Very well. I have just finished with the instruction on when the defendant exercises the fundamental right not to testify. Now, the next instruction. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any manner. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. It is as follows. Here's your verdict form. In the Circuit Court of the 11th Judicial Circuit in Miami-Dade County, Florida, 2021. State of Florida versus Terrence Davis. Verdict form. We, the jury, find as follows. On the charge of possession of a firearm by a convicted felon, the first line, the defendant is guilty. The second line, the defendant is not guilty. So say we all at Miami-Dade County, Florida, this blank day of blank, 2021, signed by the foreperson, and also please print your name under your signature. In just a few moments, you're going to be taken to the jury room, which is the other courtroom, by Robert. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Actually, he'll collect them in a little basket. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine the firearm, please advise me by giving a note to the bailiff and it will be brought into the courtroom to do so. Likewise, if you wish to view or listen to any of the CDs, similarly, give a note to the bailiff and it will be brought into the courtroom in order to do so and operate the machine. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules that we all share. Are there any objections to the manner in which the instructions have been read to the jury?
No, that's Your Honor.
Yeah, very well. Now, Robert, what I'm going to need you to do is, if you would take all of the jurors for a minute, just keep them in a line outside. I have to put one other matter on the record, and then I'll bring you all back in and then send you out for your deliberations. Okay, thank you.
All right for the jury.
All right, everyone be seated. I understand that council had already, the issue that had come up with regard to a concern that Mr. Augusto Leon was dozing off, not paying attention during the instructions. And maybe at other times, well, I did not notice it, the parties brought it to my attention, and that was the reason for the interruption. What I do need to do, though, to make clear, although the parties have represented that everyone was in agreement that we would substitute Mr. Leon with the first alternate, who is Ermina Sheridan. That's why we pick alternates. I do want to make inquiry on the record of Mr. Davis, although it was represented that he does agree with that. I think it's most appropriate for me to make sure that this is what Mr. Davis wants. So Mr. Davis, your lawyers explained to you what happened while I was instructing the jury?
Yeah.
Okay. And are you in agreement to excuse Mr. Lean? Essentially, we would switch him and make him an alternate, and then I would discharge him and substitute Ermina Sheridan, who was the first alternate. Are you in agreement with that?
Yeah.
Has anyone forced you to say this?
No.
All right, because again, this is your trial, this is your case, this is your jury. So if you have any concerns either of discharging Mr. Lean or of anything regarding the first alternate, although there was no objection previously, this is the time to voice any concern. Okay. All right, very well. So, Robert, let's try to get Robert's attention.
So before you.
Sure, that'd be someone, whoever's closest to the door. All right, everyone be seated. I know there's a lot of up and down. I apologize, ladies and gentlemen. This is on me, okay? So ladies and gentlemen, at this time, I am going to ask Aaron Rodriguez and Augusto Leon to please remain in your seats. The remaining jurors to please, you can take your notepads. Please follow Robert and you will begin your deliberations.
All right.
Hey. You can all be seated, thank you. Well, you probably guessed it now. You were selected as alternate jurors. As alternate jurors. We can't tell you that beforehand. In the event that another juror would be unable to continue to serve, or something would happen with another juror, and we always do select additional jurors. This does not mean that your time spent or the commitment made or the sacrifices you made are any less significant than any of the other jurors. It may feel disappointing because you are now not getting to the last step, which is to engage in deliberations and conclude the case that way. There's 6 jurors that do that. And again, you were chosen as alternate jurors. You both, though, gave this case your utmost consideration and attention. You've made sacrifices for the last 2 days to be here and to do your duty. We are so honored to have you as members of this community and having you serve as jurors in this case. In that regard, I have for each one of you what is just a token of appreciation. These are the instructions. The certificate of appreciation, again, which is just a small token for the appreciation that we have for you and the work that you have done. I feel sad. I'm sure it is disappointing, but you've done a wonderful job, both of you. But at this time, let me also tell you, you have a right to speak to anyone you wish to speak with about, your thoughts and impressions. They may want to speak with you about this. That's up to you. You don't need to speak with anyone. At this point, I am going to discharge you. You're free to leave. And again, with the thanks of the court and with thanks of all of the parties, thank you for your commitment to justice and for advancing the causes and in making sure that we continue to maintain the integrity of this branch of government through our citizens like yourselves. And thank you again. Both of you can leave the notepads there as well. And you can meet Robert right outside and he'll give you any further instructions or if you have any questions of him. And at this time, you are both excused. Thank you so much.
Yes. Thank you for everything.
All right.
Okay?
That's the first time I've seen him in person. Exactly how I would say.
All right, for the jurors.
All right, everyone, please be seated. Thank you. All right, ladies and gentlemen, it's my understanding the jury's reached a verdict. Is that correct? All right, and who is our foreperson? Madam foreperson, your name is Miss, let's see. Is this, what, tell me your name.
The relevant.
Miss Rowe? Where? How come I can't find you on my list? Okay, I can't see anything. Help me. Help me, Chris. Right there. Oh, I'm sorry. That's tonight. Thank you. Could you please hand the verdict form to the bailiff? Oh, it's been a long day. All right, thank you. You may have a seat. Thank you. The court has reviewed the verdict form. It is legally sufficient. There are no errors or omissions in the filling out of the verdict form. I'm going to ask Chris, my clerk, to please publish the verdict.
In the circuit court of the 11th Judicial Circuit in Miami-Dade County, Florida, 2021, State of Florida versus Terrence Davis. Case number F20-14391. Verdict. We, the jury, find as follows. On the charge of possession of a firearm by a convicted felon, the defendant is guilty. So say we all at Miami-Dade County, Florida, this 18th day of June, 2021. Darrell Knight, foreperson.
Does counsel for either the state or the defense wish for the jury to be polled at this time?
Yes, Your Honor.
Chris, would you please poll the jury?
Members of the jury, you have heard me read the verdict. As I call your names, if this is your verdict, please answer yes. If this is not your verdict, please answer no. Oscar Cordado.
Yes.
Darrell Knight.
Yes.
Jolene Gonzalez.
Yes.
Nicholas Cesarano.
Yes.
Albert Lyons.
Yes.
Ermina Sheridan.
Yes.
The jurors are seated in the verdict. Your Honor.
All right, thank you very much. You all may be seated. Thank you. Ladies and gentlemen, I want to take this opportunity to thank you for your time and consideration of this case. I also wish to advise you of some of the very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that have occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair, as long as they wish it. Therefore, the law gives you the unique privilege not to speak about your work. Although you are at liberty to speak to anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, I want to thank you again for making the sacrifices that you have had. You can give it to them when you go outside. The sacrifices that you have had to make in order to do your duty and to serve on the jury. We know it is not only sacrifices of your time and energy, you're putting aside your own personal matters in order to serve your community. It is essential that we have citizens in this community, and we're very fortunate to have citizens in this community who continue to understand their role and importance in the justice system and in government. This is the place and the only place where you as the people serve and you speak. Again, thank you so much for expending your time and your energy and your sacrifices for doing this job. Robert has for each one of you, and he'll give it to you outside, a small token of appreciation, a certificate of appreciation, which is again just a token for the appreciation we all have for the work that you have done and the sacrifices that you have made in the interest of justice and in maintaining this branch of government and keeping it strong as it needs to be. Ladies and gentlemen, at this time, you are now discharged. Thank you very much.
All right for the jurors?
Oh, leave your notepads at your
You
seats
can
if
leave
you
one
would.
out there, I'll pick them up.
Yeah, just leave your notepads at your seats.
Yeah,
Thank you
just
so
leave it
much.
there, I'll pick them up. All right.
All right, everyone please be seated. Thank you. All right. Based upon the jury verdict, the court is going to adjudicate Mr. Davis guilty of the offenses charged possession of a firearm by convicted felon. I've signed the fingerprint page now. Now, does the defense wish for a pre-sentence report to be prepared in this case?
Yes, Your Honor.
Now, we need to schedule a time to do that. And frankly, it's going to take a lot longer than in past times. So I'm going to say, let's see, today's is the 18th.
Yes, sir.
So let's see. Let's look at July. July 21st.
That's fine.
July 21st for the pre-sentence report. Okay? That'll be return of the pre-sentence report. And then, frankly, at that time, I'm anticipating within a week of the return of the pre-sentence report for us to set a sentencing hearing.
Yes, sir.
All right. So I should probably set both now. We'll say the 21st for the return of the pre-sentence report and the 28th for sentencing hearing. So that leaves us with this period right now. Is there anything further from either party?
Yes, Your Honor, we can address Mr. Davis' custody status. Or the sentencing.
Well, I haven't heard anything from the state on that, and it's an interesting position the court finds itself in, because
Your Honor, just to confirm, you said.
well, let me finish my sentence and then you can say what you need to say. Mr. Davis's sentencing guidelines, I think were 19, what were they? How much were
Your Honor, he scored 20.250.
20. That was 9. Okay, I was close enough. But,
Yes, Your Honor,
all
he
right.
is enhanced as an individual violent felon. And,
Okay.
he does have a 10-year minimum mandatory as an HBO, which we already addressed, but if Your Honor should make the appropriate findings on the record, that can be waived by Your Honor. For the case of a 30-year state prison, which is double the normal or, you know.
Charged with the second-degree felony,
That's
so he
correct.
faces up to 30 years.
So at the end of the day, Judge, I mean.
And what's the bottom of it? And you said 20 months, right? It was 20-something
20,
months?
22, yes.
Okay.
And Your Honor, again, I don't wanna. I wanna do what's appropriate in each and every single case. If this. I don't know the back history of, his term, you know, what his pretrial release has been and how well he's done. And I can't inform Your Honor if there's been any violations. I can't make any representation. I can't say he's been a perfect angel. I don't know those things.
Okay.
I would say that in the case where the jury's returned a verdict, I'm going to treat this case like we would any other, and I would be asked, I would ask Your Honor to take him into custody pending the sentencing. I do anticipate that Your Honor, he's at the bottom, you know, 20.25 months in prison.
I understand.
Can't go below, you know, below that.
I understand, unless of course it was something presented to me in mitigation, which,
That's correct. I mean, mitigating, you know, a downward departure could certainly be presented. I don't know these things.
and of course, Mr. Davis has a right to appeal. And the processing of appeals, you know, you have to balance all of that in terms of the time it takes to process an appeal. So,
Your Honor, I'm going to be 100% honest. I don't know what the standard is. I don't know if, he doesn't, I don't know if he has to be taken into account. I don't know that. You know, I would, you know, at this point in time, I don't know what standard or whether I can interject and jump up and down and say, no, Judge, you have to take it into custody. I don't know. Your Honor has been moving this far longer than I have. And at this point, I would need to go back and confer with my office and, you know, the office and find out what exactly, you know, what we can do here when we're in this position.
all right. Anything
something
else,
sense.
anything else the defense wants to say about that?
Yes, Your Honor, if it would be at all possible to allow for Mr. Davis to remain out of custody